Good morning, Your Honors. This is a continuation of the public panel interview of the candidates for the position of Associate Justice of the Supreme Court, Vice Honorable Associate Justice Mario V. Lopez, who will compulsorily retire on June 4, 2025. Please all stand for the centennial prayer for the courts.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Please be seated. Let me introduce to you now the members of the Judicial and Bar Council who are present in today's public panel interview. We have the Honorable Justice Jose Catral Mendoza, regular member representing the retired justices of the Supreme Court and JBC Executive Committee Chairperson. Honorable Attorney Nesauro H. Firme, regular member representing the Academe. And Honorable Justice Erlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. May I now refer you to the Honorable Justice Jose Catral Mendoza to officially open today's public panel interview.
The public panel interview of the candidates for the Supreme Court, Vice Justice Mario Lopez, is now open.
Your Honors, the candidates to be interviewed this morning are Honorable Court of Tax Appeals Associate Justice Maria Rowena M. San Pedro and Honorable Court of Appeals Associate Justice Walter S. Oong. May we request the candidates to please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Justice San Pedro to please take your seat in the middle and Justice Oong to please proceed first to the holding area. Thank you po. You may take your seat. Your Honors, the first candidate to be interviewed this morning is the Honorable Court of Tax Appeals Associate Justice Maria Rowena M. San Pedro. The first to interview Justice San Pedro is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice San Pedro,
Good morning, Justice. Good
my
morning,
former
Justices.
colleague in the CTA. I have two sets of questions, one from the Secretary of Justice, and I will be asking them on his behalf, and then I have my own set of questions. So I will start with the questions of the Secretary of Justice.
Yes, Justice.
You authored the WIPO bench book and led the development of bench books for commercial courts. How do you think bench books should influence, not dictate, Supreme Court jurisprudence and the lower courts' adherence to the doctrine?
Okay, Justice, I'd like to explain that, for instance, for the first commercial bench book we prepared for the commercial law courts, that was clamored for by our judges. This was brought about by my many years of lecturing to commercial court judges in particular. They had the difficulty for difficult cases like rehabilitation. So what we wanted to do was to give them something, a bench book that we thought of, that will guide them through the process and give them something that's not found in textbooks. Because sometimes I remember a judge say, ito lang pala yun. What they want is something that from the very time they receive the case, it will guide them and make it very simple. That's why even the methodology we use in the bench book, we use a question and answer form. So just to guide you, for instance, the first step there is, when you receive the petition, what should you look for? And then in the bench book, we put tables, we put time frames, we put examples of issuances. We even put all the latest decisions from the time, for instance, for corporate rehabilitation, from the beginning to the latest case summary. So, and then with respect to the WIPO, it was also not just for local judges, but for it's available online for free for other jurisdictions to see. That is a source of pride for me because it was a way for the Philippines to show how competent, how sophisticated our rulings are to other jurisdictions. As a backgrounder, when I was new, when I was starting to work with WIPO, they asked me, they interviewed me way back in 2018, what was my wish list as a commercial court judge. And I said, I wish that there is a portal where we can use, where we can look at other jurisdictions. Because as a judge, and even as a law student before, it was only the US that was the go-to for foreign jurisdictions. And I said, it would be nice to see how Korea, how Japan, how Indonesia, how India is ruling on the same issues because they're more in the same complexion as ours in the Philippines. And lo and behold, they came up with a portal, the Lex, WIPO Lex, where we now also include our Philippine Supreme Court decisions. And then from there, I was invited to write the first in the series of bench books for globally, which was for the Philippines. That helped, again, we launched it here and we didn't stop there. There's also now a distance learning course that we offer. And our commercial court judges, from the last survey we made, 99% of them said it's really helpful. 99% of them said they use it in their decisions. So both for the local bench book that I shared and for the WIPO, it's really meant for the work for the judges to make their lives easier. And, you know, if they want to go deeper, they can go to the textbooks. But this one is really a Q&A kind of manual. I hope that answers it, Justice.
A follow-up question, my own. You mentioned distance learning course. This is being conducted by PhilJA?
No, the distance learning course was also developed by WIPO with the support of the Australian government, but they also contracted me because it was based on the bench book that I wrote for them. So it's in the WIPO website, but they're offering it in partnership with the PhilJA, with the LOA from the Supreme Court to our local judges. We were able to launch it last year and around 50 judges participated. And after around 2 months of going through the distance learning course, we had a face-to-face colloquium here where we had actual workshops to test their knowledge culled from the distance learning. In fact, it's going to be an ongoing process. We have, again, another one in August where we have around 70 this time, local judges, and we'll have another 2-day colloquium face-to-face.
Second question. As a recognized international expert on intellectual property adjudication, how would you handle the evolving conflict between IP enforcement and digital privacy or freedom of expression concerns?
Again, Justice, I'm sorry, the conflict between?
How would you handle the evolving conflict between IP enforcement and digital privacy or freedom of expression concerns?
Okay. I don't know, this is quite related because I'm also involved in cyber warrants. And in our training, we have Justice Leonen lecture on privacy rights. So I think that with that, I think it's a good model that every time we roll out training to our judges on IP, it also involves a parallel lecture on respect for privacy rights. Right now, for IP, I don't see much of a conflict because private rights, in fact, copyrights are respected more and more. I think this was reflected in the recent decisions of the Supreme Court involving PhilSCAP. But with respect to privacy, I don't think IP infringes on that.
As an MCLE lecturer on rehabilitation and insolvency, do you believe current jurisprudence on corporate rehabilitation adequately protects stakeholder interests, or does it lean too far in favor of debtors or creditors?
There was a amendment to the FRIA where now, whereas before the creditors could freely apply for rehab with the courts, and the approval of the rehab plan was really a coordinated effort between the creditors, the debtors, and the court. But now it requires the concurrence of the debtor creditor concurrence. But then the crammed down powers of the court was not completely taken away. If in the interest of the debtor, the court can still approve the rehab plan. I think the rehabilitation decisions of the Supreme Court, although now I noticed that before, when I was a commercial court judge, there was an influx of rehab cases. I was thinking that because of COVID, there will be more. But I was told that not as much as during the times during the Asian crisis. As an aside, I'd like to say that the rehab was one of my favorite cases when I was a commercial court judge, because it just gave me such satisfaction to see how we can save fledgling corporations who were really, really just negatively impacted by the Asian crisis. And then some judges then would ask me, why do you like it? It's so difficult. Because it's not like your usual cases that fall to you. But I said, it's a joint, there you'll see really the cooperation between the creditors and the debtors. And it's nice to see how they can come to agreement, and you see how reasonable they can come. But that said, the court always balances the interests of the creditor and the debtor. And that was also one point where I was able to inject ESCR. I think it was a mining case. And then we included their social responsibility. We asked them to make sure that because of the sacrifices of the community, they had to also give much. So we were able to put in the aspects of economic, social, and cultural rights.
Number 4, it can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
I think it's already embedded and widely followed by our Supreme Court, that the Supreme Court is the final arbiter, and that aside from its duty to be the arbiter of actual controversies, it's there to check the balances between legislative and executive functions. So it's the grave abuse of discretion that I will look forward to, cases on that. And always to look at the Constitution as the final say in everything that comes out from the decisions.
With your long years of practice of law and now as an applicant for a Supreme Court justice position, can you share to us your judicial philosophy?
Okay, I would like to start by saying that for me, and we already, based on your previous question, my loyalty will always be to the Constitution. But that said, I will not shirk from the opportunity to be an activist judge, especially when the situation calls and for social justice to be put forward. And I will only do that if the Constitution is not clear. I think the Supreme Court also has the duty to see that justice is served, and sometimes it cannot stop with just a black and white interpretation of the Constitution. If I may share, sometimes my role as a judge has been marked by instances, not very often, but there were instances when I went beyond what the law called for. Like I remember an anti-trafficking case in Pasig where there was an accused who I convicted of trafficking minors. So in the end of my decision, I had to include, sometimes they say that's not necessary, but I had to include with the paragraph that said something like, I cannot end this disquisition without calling on the Pasig City government and the Department of Social Welfare to see to it that to try to put measures to curb the prostitution and trafficking that is being done, especially for minors. And I specified specifically where it was being done in this place in Pasig. And then my next paragraph also was to say that insofar as the penalty, it was a straight penalty of 20 years, which personally I felt was too much for that accused. But I said the hands of the court are tied. So I refer this to the Congress for possible action. So in those instances, when I see that there is a need to speak out, I don't shirk from that responsibility. Thank you.
Do you have a particular justice here or elsewhere whom you consider an idol, and why?
I have two. I have three ladies. The first one is Justice Melencio Herrera, and she was the one who serendipitously got me into PhilJA. Justice Herrera is the epitome of elegance and integrity. My second one would be Justice Estela Perlas Bernabe, who was my mentor. I started with her in the commercial committee, law committee. Also, I look upon her because she started from the MTC like me and worked through RTC, CA, and the Supreme Court. And on a personal note, I admire her because her relationship with her husband is so sweet. And I like that to be marked also with my husband. And finally, my good friend Justice Monette Singh, because we've been partners for a long time. And I just admire how dedicated and passionate she is with her work and how she's so strong. Yes, those are my three. Of course, Justice Lynn, I cannot say because you were my chair. And you, again, like Justice Herrera, was my epitome of professionalism and elegance.
I noticed they're all ladies.
Yes.
Anyway, we will not be accused of gender bias. Assuming you were appointed to the Supreme Court and given the, I think, long number of years, right? Long number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Okay. First, if given a chance to be with the Supreme Court, I'd like first to work on what is already there. There are so many wonderful innovations already in place, especially with the SPJI, which I totally support the efforts spearheaded by Chief Justice Hesmundo. Second, if I'll be chosen, I will look into the projects and policies started by Justice Mario Lopez, and I will see to it that I can continue those because I believe that there are already so many in place. And the problem sometimes is like in politics, when somebody leaves, it's abandoned. And then so I'd like to go for continuity and sustainability. That said, there are other things that I'd like to introduce. Maybe my advocacy from the very beginning has been court forms. And I was in the committee that worked on court forms. I'd like to see those court forms really used in the mainstream. That's one. Second, I'd like to see unfortunately, Secretary Remulla is not here. I'd like to see it to look into the wisdom of going into plea bargaining and really using it. Because in my research, when I worked in the Misuari case, it came to my attention that only 6% of criminal cases in the US proceed to trial. Most of them really are threshed out because of plea bargaining. Now, what is the reason why plea bargaining is not successful in the Philippines? Because our rules require the conformity of the private complainant. Our Supreme Court decisions are already, there are so many Supreme Court decisions already outlining what is the role of the private complainant in criminal cases. And that's really just with the civil aspect. So consistent with that position, I think we can look into not anymore including the consent of the private complainant for plea bargaining. That will really do so much in freeing up the court dockets in criminal cases. And I would like to say also, plea bargaining is not a loss, it's a win-win, because you have a conviction, albeit for a lesser degree, and then you free up time, effort, and expenses, costs.
In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, no crime without law, with the evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? Should the judiciary have the power to recognize new crimes absent explicit legislative provisions?
I think crimes should always be backed up by clear legislative provisions, because that is part of the due process for the accused to know what he's being charged of. But that said, perhaps to keep up with the technology, because it's so fast, you can always cluster acts into certain crimes. They can fall into a crime while there is no specific crime set for that particular act. Some acts can fall into crimes that are already existing. It's just a matter of looking at the acts and finding out which laws already punish these acts.
The principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences, which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
Again, if the judiciary finds that the law is wanting, the judiciary always has the mechanism of bringing it back to Congress. But I believe that what Dura Lex sed lex, if that is the law, then we should follow it. That ties it up again to my frustration before, that I had to mete out the straight penalty of 20 years, even if I thought that the accused only deserved 5 years. I had no, it was out of my hands. My hands were tied, and I had to mete out that penalty that was prescribed by law.
In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? How should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
Okay. Media sensationalism is getting to be a big problem. It used to be, and attacking the judiciary in particular, trying to influence our decisions in the judiciary. It used to be, I said, that when I was a law school, the Supreme Court were the gods of Padre Faura. But even now, even the Supreme Court is not shielded from media attention. That said, I think as judges, we should shield ourselves from public perception and really have blinders to apply only what the law and jurisprudence calls of us. I know it's a difficult task, but, and then we shouldn't also be slaves to the evils brought about by false news. And I think the PIO is doing a wonderful job. They said, how will the Supreme Court tackle all these media and actually social media slurs? And I think the way to do that is to not to attack them firsthand or directly, but to have a parallel information campaign. And I think the PIO is doing a good job. They're coming up with blogs and even animation that's taking the interest of the public. Because really, that's the medium now, especially for the public. While we should shield ourselves from being influenced by false news, we should also not ignore the power of the social media.
Last question. What unique perspective do you believe you offer that current member of the Supreme Court may not possess? Negative.
What unique that the current members do not possess?
Yes. but you believe you possess.
I don't think that I have a monopoly of anything that I would say that I am computer savvy. I've been using a laptop since 2001, since I started my stint as a judge. But I believe that Justice Lonen, for instance, is very computer savvy. What else? My skills of judicial writing, everyone does. My skills in judicial education and reform, the Supreme Court justices have that. So I don't think I have any particular skill that is not shared by at least one. Maybe pickleball, Justice. I tried to ask Justice Maidas if he'll join me in pickleball, and he said, mabagal yung sport na yan. So I don't think so, Justice.
See, I'll now proceed to my own questions. You have thoroughly answered the questions of the Secretary of Justice, and so I'll just have few questions. In your 5 years in the Court of Tax Appeals, that's more than 5 years.
More than, almost
Yes,
6.
Almost 6. 13 years in the RTC and 3 years in the METC. Is there any significant case or legal decision you rendered which had a profound impact on you? I think you mentioned some already, but anything else?
Well, of course, the Miswari case, that was very challenging. We had more than 200 accused there. I had an opportunity to go to The Hague when I was working on that. And the American and the other European counterparts were complaining about how the complex their case was. One said they had 6 accused. One said, oh God, we have 20. And when they saw me with 200 plus, and I was still small then, they said, how can you handle 200 plus? And then, so that's one. And I handled it in a very different way because of the number of accused and my training in commercial. Every time I'd go out, I would have a agenda. So I treated it like a stockholders meeting or directors meeting every time. I didn't treat it like a regular case. So in the agenda, and I would give this beforehand to the prosecutors and the defense. And then I also had a case briefer because of the 200 and they couldn't go to my court all the time. At least every other month, I would send the PAO, the prosecutor, and an officer from my court to go to the detention center to give them a briefer of what the case situation was. This is a funny story because usually the other cases when detainees come to my court, I try to give them merienda like sandwich or drinks, ganyan. Kasi 5 lang naman yung detainees. So nung first sabi ko, 200 plus. How much is KFC? And oh my God, ang mahal pala. So we ended up banana queue. So I would try to do that and that was memorable to me because, and that's where I was able to do the first vetting. I had to dismiss a lot. You cannot blame them because during that time, anyone who looks suspicious in the corner, they will get. So because it's a war, there was a war and there was violence. So the moment it was filed with me, ang dami nang na-dismiss, no? And then I asked the DOJ to look again. And then we were able to, by plea bargaining, we were able to cut it. I was frustrated at one point because I said, this is not conviction. But I was told by one Supreme Court justice, that in itself is already a win when you have plea bargaining and you were able. So from 200 something, I was able to bring it down to around 69 remaining detainees.
May I know what charge?
Crimes against humanity, rebellion. And then, so that's one. And the second, of course, I think has been widely discussed in criminal subjects is the Ivler case. I was still a young MTC judge then on double jeopardy. And even if I was reversed by Justice Tony Carpio in the Supreme Court, my source of comfort there is that he recognized there was a gap. And again, there was a referral to Congress.
Going back to the Miswari case, you resolved it through plea bargaining?
Plea bargaining.
Or were there some who were sentenced?
No, it never came to trial while I was there because this is a long process to get them to we had to amend the information so that the private complainant is not. That was difficult also because there were really no names of private complainants. It was funny because the members of the Council of Zamboanga came to me, but the mayor couldn't because she was scared that I would be able to convince her, and it was very difficult. This is political, and that was also memorable for me because that was when the government asked that Miswari himself the case against him be suspended because they were right in the middle of peace talks. So I came up with a resolution, and I think that's one of the resolutions I submitted, that I said this is a case of where it's a political question. So I granted that suspension.
Your sala was a commercial court.
Commercial
So
court.
why the Miswari case?
Okay,
By
when
special raffle?
When I was given the commercial court, when I was able to bring down my case docket to 50, of course, the Supreme Court gives you the gift of giving you another appointment. They made me a family court as well. And in the Miswari case, there were minors. That's why it came to my court.
And you went to Hague. May I know the purpose?
I was invited to go to Hague for a anti-terrorism conference, and I gave a lecture on children witnesses. And that was a good opportunity because I was able to watch the proceedings on I think it was the ICC for former Yugoslavia. And imagine how envious I was of all their facilities. But the international community, they were so helpful. I remember when they talked to me, because I was the one there with the spectacularly large number of accused, the American judges even sent me by slow mail materials. They were so helpful.
So this is related to the case of Miswari?
Yes.
I see. All right. Can you describe a challenging ethical dilemma you faced in your judicial career, and how did you resolve it?
Okay, this was not yet when I was a judge, but when I was a researcher in the Supreme Court, and remembered at that time the death sentence was not yet suspended. So personally, I don't believe in the imposition of the death sentence. I believe in the inherent right to life. So when cases, you know how researchers are, they give you for you to suggest the drafts. I had no choice but to mete out the death penalty when warrant. But that said, we were quite free then. So the death penalty impositions were in red folders. I don't know if that's still the case now. So I would go through all the red folders and find those where the qualifying circumstances were not stated, so that I would find a way. I volunteer? Can I do this so that I can just make it reclusion perpetua? But again, even if the law, my duty goes against my personal, I have to do it. If you cannot do it, I think then you have to step back and quit, because that is your obligation, that's your duty.
If appointed Associate Justice of the Supreme Court, how would you approach a complex legal issue with multiple potential interpretations?
When I work, and I also say this even to my children before, I think in outlines. So no matter how complex an issue is, because I work in outlines, I cut them down, and they become more manageable for me. So I think even no matter how complex an issue is, if you will just know how to handle it and break it down, then I will be able to handle it.
My last question, what is your opinion on Supreme Court decisions which overturn judicial proceedings? What will be its impact on decisions of the lower court which have become final and executory?
Okay. Final and executory decisions can no longer be disturbed. I know several decisions that have changed existing jurisprudence, and there's one now that I particularly appreciate, the one that said that even the Filipino spouse can ask to be the marriage to be dissolved, even if she was of the foreign spouse. So it doesn't, I think it was a decision Manalo by Justice Peralta, that he said it's not limited to the foreign spouse. I know the law seem to be clear that if it's the foreign spouse who obtains the divorce decree, then the Filipino spouse is free to remarry. But I read the decision, and now I think it's fair that we protect our citizens. And so that one has an impact on cases that have already been decided, because so many cases were denied because of the interpretation before. So that is one example, Justice.
So that's my last question. Good luck to you, Justice San
you.
Pedro.
Thank you, Justice Uy. Thank you.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Marife. Good morning.
Good
Justice.
morning, Attorney Ferme.
So, do you have barbecue right now?
Sorry.
Banana Q? Do you have
No.
banana Q?
But I prefer to run.
Okay. So my first question, Justice, if appointed as an Associate Justice of the Supreme Court, what can the stakeholders expect from you?
Okay. I think in my more than 31 years in the judiciary, I've developed a reputation, I'm not going to be modest here, of excellence. Excellence because I really strive to be prepared every time. I think Justice Linda saw that. Even from the time I became an MTC judge to RTC and CTA, I was late only once. And then, well, maybe because in the lower courts, my cases were scheduled in the afternoon. But that one, I never go out without being prepared. I read every folder that's set for the day. So excellence in being prepared, I promise that. And then industry, no matter how tired I am, because I'm a nerd. Sometimes I don't like to do it. And then when I start reading it, I go further than what is expected of me. That's two. And then I will still, integrity is, I think I've developed a reputation also for integrity. And then I will continue with my work in judicial education and judicial reform. I think aside from my adjudicatory functions, I've been known for that. And I want to continue that in the judiciary. Of course, not on my own, but in consonance with what is already in place in the Supreme Court. I'll find where I can, if they will accept me in those. And then also that, again, like I said, my focus will be on social justice. Sometimes, and this is also true during my trial court experience, some judges stop. They say they're of the opinion that you are here just to receive evidence. But me, I always had clarificatory questions. During trial court, I said that to the prosecutor and PAW, if I don't give clarificatory questions, that means you did your job. Because this is just a story. Every testimony is a story. If there are gaps, I already have in reading the JA, I have questions in my laptop. And then it's nice when the trial proceeds and one of the lawyers asks it, so I cross it out. But if there are remaining questions, that means they didn't do their job. So that is also my work. No, I try to really exhaust, but always they can rely on me to always uphold the rule of law. Because like I said, no matter my personal opinion, it's always the Constitution, law, and jurisprudence. And finally, I think I'd like to think that my decisions are all clear. I want to make them as clear as possible. Thank you.
Thank you, Justice. You are on your fifth year?
Almost six.
Almost
this
6 years
July.
as it. And presently, Justice, you are senior member or a chairperson?
Senior.
Senior
in
member.
the second division.
In the second division. So, you are aware, probably aware, that some of the applicants here have rendered more than 10 years in the Court of Appeals.
Yes.
Okay. So the question would be, to what extent, no, do you adhere to this seniority rule?
I respect seniority very much. But with respect to seniority rule for the Supreme Court, I think my many years as a MTC judge, trial court judge, now with the CTA, has brought me finally to this point where I think I am ready. And as much as ready as the other applicants are.
So what do you think, Justice, is the underlying basis or reason for this seniority rule?
Seniority because especially if there is an age factor coming in. If I may share, when I was an RTC judge, there were many opportunities already for me because you see, MTC, it was very fast for me. I was just there for 3.5 years. In the RTC, medyo matagal na ho yung 14, na, at least in my batchmates. There was an opportunity for me early to apply for the CA. But I said, I will not yet, because at that time, there were many colleagues of mine who were older, senior, in age especially. And they said, pagbigyan naman kami ng mga mas nakakabata. Kasi, and I said yes, you know. And every time I always feel that I applied for the CTA thrice. And those 2 times I didn't get it, I think God really protected me because He wanted me to bear awas. In the 2 times I didn't get it, there were so many things that happened in my career. So it's really God's perfect time. And I think now, after 6 years, perhaps it can be already.
So correct me if I'm wrong, Justice, no? You have 32 undecided or unresolved cases within the prescribed period?
The extensions I asked?
Yeah.
Yes. Those extensions, if I may clarify, majority, maybe 98% of those were already being routed. I had to ask for extension because hindi pa na-sign ng lahat. But very rarely did I go past the 1-year period. They were already being routed, except that because of there are 9 of us who have to sign it, we couldn't get the signature of all.
So just a personal question. In CTA, no, would you know, Justice, how many cases have been dismissed? Well, both probably criminal would be resulted in acquittal, but for the collection, ordinary collection cases, how many cases have been dismissed?
I don't have the figure with me, unfortunately, as
But at least
a whole.
a percentage,
You know, I think more dismissals.
more dismissals.
Yeah.
What do
And
you
that's
think?
frustrating.
What do you think is the reason behind that?
With due respect to the BIR, I also find it a curiosity because sometimes it's really technicality. Number one is that the auditing revenue officer has no LOA. That is so basic. I mean, if paulit-ulit it's dismissed because they had no authority, LOA, you would think that the next step with them would be to push their revenue officers, be sure to follow this LOA, LOA. So many get dismissed on that ground.
As for the acquittal, Justice,
Okay, acquittal again. Sometimes the prosecution really lacks evidence. And again, even in the acquittal, it's technicality.
so have you done something extrajudicial, no, to address this one? Because I understand, and I know you would agree with me that if ever there will be an outcome, no, that would result in the collection or a decision that would be against this taxpayer, we would be able to collect taxes,
Yes.
and that would be good for our country.
Yes.
So the question is, have you done something extrajudicial that would probably help us in collecting cases due to the state?
I think, Attorney Firme, normally you would have roundtable dialogues with the BIR, but I think the decisions speak for themselves, especially the number. I think it would behoove the BIR to really see and maybe have an extreme training program for their men on the ground. So it's really a curious matter for me.
So maybe after this interview,
Maybe.
they will be enlightened.
With due respect.
You mentioned earlier, right? God speaks in different
Yes.
ways. Diba? Probably this could be it.
Although I wish nobody watches the interview.
Okay. You are a member of the Supreme Court Committee on Commercial Courts.
Yes.
And I think, and you mentioned earlier, I confirmed it, that RTC 158 is a commercial court.
Yes.
So what is your criticism to our FRIA law?
Freya?
FRIA law. I have handled a FRIA law and I have some criticism on it.
Could you tell me and I'll tell you if I agree?
Oh.
Because like I said, Freya was my
Debtors are not real.
favorite. My favorite.
Debtors are not real.
Sorry?
Debtors are not real.
Debtors are not real.
Yeah.
I've not
They're just made
encountered
up
that. Well-
so as to pad the number
Amount.
of the expenses, or to make it appear that the company, no,
Is in debt.
applying, no,
Yeah.
has many debts.
Yeah. Well,
Most of them are sister companies.
yes. And one thing before, when like you have 4 sister companies and then the rehabilitation receiver, that's one frustration. And I've been bringing it up already, even to the Managers Association of the Philippines. We should have a system of accreditation for rehabilitation receivers. When I was new, I was just shocked that one rehabilitation receiver can earn as much as 500,000 a month. And then there was one where there was a rehabilitation cases with 4 sister companies. And the receiver wanted 150 per company. And so I struck that down. You're doing the same work, just one. And sometimes judges like me, I don't know people from the financial sector. You don't know who, you just depend because these are nominees of the petitioner. I wish, and we've been bringing it up for a long time, that there will be some form of accreditation system for rehabilitation, just so that the fees are regulated and that only professionals are. It was also frustrating for me to come up with a rehab case where the receiver was not even such a professional and kilala lang nung petitioner. So immediately, it fails when you could have been given a better rehab plan if you had a good receiver. I've had very good receivers appear before me, but that one, no, a lack of monitoring system for receivers. More than rehabilitation, my frustration is more with insolvency cases because there, you need all the creditors to appear. And sometimes hindi mo na mahanap yung creditors. You cannot find them in one room. You need a certain percentage for them to vote for a liquidator. And that is the frustration. Sometimes it can go on and on that you cannot get a quorum, you cannot get the required vote. So maybe that is something for Chair Francis of the department can look into. Thank you.
With respect to corporate rehabilitation, this is the question of, for instance, during the pendency of a labor dispute, no, the employer filed a case, a petition for corporate rehabilitation. So the court now then issued a suspension of payment. But notwithstanding this, the labor arbiter still proceeded, no, in hearing the labor case. Of course, the employer, not happy with what the labor arbiter did, no, elevated it to the NLRC, citing grave abuse of discretion. No? So, first question, you can easily answer this one. Is the labor arbiter correct?
If I recall right, all claims should be with the rehab court.
Including pending labor cases.
Honestly, I never had one where there was a pending labor case in all the rehab cases that I did.
What do you think the Supreme Court said?
Labor will be given preference in the claims.
Now, the much on the technical aspect of that case, can the NLRC rule on the alleged grave abuse of discretion committed by the labor arbiter? Remember, the mode of appeal from the labor arbiter to NLRC is ordinary appeal. It's just an appeal. Can he rule on the alleged grave abuse of discretion?
Grave abuse.
Does the NLRC have the power to issue writ of certiorari?
If the petition was not a certiorari and limited only to a regular appeal, then the certiorari has no place in the, maybe that's the wrong mode of appeal taken by the...
Diba, nag-file siya ng notice of appeal from the labor arbiter to the NLRC. Notice of appeal. But instead of citing serious error committed by the labor arbiter, the grave abuse of discretion, because under the rules, the the labor case should have been suspended, no, pending this corporate rehab.
Okay, based on your facts, Your Honor, I would say that even if the appeal mode was wrong, but a look into the justice aspect of it, the court sometimes will go over the error in the kind of appeal presented and rule into the merit of the question of grave abuse of discretion, as long as it was clearly stated in the allegations. Sometimes you can relax and take the mode of appeal interchangeably.
In labor, again, also, Justice.
I have to say that I have never encountered labor cases. I'm sorry.
No, it's okay.
Yes.
No, it's very interesting that because medyo kakaiba the questions that I've been asking, no. And these are questions also coming from the academe, so I have to read them anyway, no. So there are two kinds of labor contracting under the labor code, no? The legitimate labor contracting and the labor only contracting. So the Supreme Court said, no, that in labor only contracting, the principal becomes the employer of the contractor's employees. Now the question is, do you agree with that? Is it not that, no, the power to hire? No, what the point here is, does the Supreme Court establish a relation between the contractor's employee and the principal, or does it merely establish a relationship? Does it establish liability or relationship?
I think if the Supreme Court, in its wisdom, considered the employee of the principal, it would have looked into matters like control, and specifically control, if they had control of the going down the line to the actual employee, if they had power, even if the salaries were being taken and dictated by the principal, then those, in essence, it's really to do away with the middleman and to see and protect the employee from a situation where the liability of the middleman may bar them from obtaining what is just to them.
What is created? Liability or
Unemployment and
a relationship?
a relationship.
A relationship.
As long as those as long as those elements are present. Again, it's in a viewpoint of it's with the end viewpoint of protecting and giving the employees what is due them.
So under Article 109 of the Labor Code, it's very easy. It's actually more on the philosophy. Every employer or indirect employer shall be responsible with his contractor or subcontractor for any, that's the emphasis, any violation of the code. Some Supreme Court decision interprets this phrase, any violation, no, to be confined to wages. But some Supreme Court decision, it's broader, not only wages.
Yeah.
So, for instance, I'll give you an example. No? A company secured the services of an agency that will provide them with janitorial services. Now, what if this agency engaged in janitorial services illegally dismissed these janitors which are deployed at the principal's office? Question is, can this principal be held liable for illegal dismissal? If you are going to construe this any violation, no, is it limited to wages only, or it would go to the extent of being liable even for illegal dismissal?
I would go to liability even for illegal dismissal, Your Honor, because Again, social justice requires that the middleman should not be shielded if the law already states that the principal will be obliged to
But assuming this is a legitimate labor contractor,
yes, but the law does not make any exception. Yes, the law does not make any exception. That I guess if we look, maybe we can look into the legislative intention. If right now, I promise you, because I don't know much about labor, but when I will look into it, I will exhaust my research of it and even look into the intention of what that phrase any violation. Because on its own, any violation would just be, you will look at it as any violation and not limited. In fact, there was no specific mention of limited to wages, because if that were the intention, then that would have been expressed in the law, meaning it would have been complete in itself.
in fact, the Supreme Court is
Yes.
diverse
Oh,
in its opinion. That's why I'm asking you.
then maybe I should refrain, because if and when I am included, then they will already know how I will rule. Thank you.
Okay. So I'm about to ask you some cases on taxation. You would easily answer them. So I'll skip them. So criminal law. No? You handled criminal law in Pasig.
Yes, mostly VAUSI
Yes,
and trafficking,
Okay.
those related to family courts.
Well, this one is different because we just had our election few days ago. So for instance, a person was, during this barangay election period, it's barangay now. So during this barangay period, a person was caught carrying firearm. So the prosecutors filed a case against him for violation of the COMELEC's gun ban law. The following day, after his apprehension, a law took effect, stating among others that the barangay election is postponed. Now, the accused filed a motion to quash the information. Why? There is no offense to speak of.
Because
Election gun ban, there is no election. Now it is elevated, assuming, the matter elevated to Associate Justice of the Supreme Court, San Pedro. How would you rule on that?
I think he would still be guilty, because at the time the act was committed, there was a valid law. It was valid law at the time the act was committed.
So that's the dissenting opinion from them. It can be given retroactive effect. It's interesting case.
It's interesting, but
Yes.
really, the opposite operative fact doctrine naman, that if it's illegal, once declared illegal, everything would have been valid before that. So here, I'm just looking at the reverse. If it's valid, everything would have been illegal before that. And because it had already crystallized, or it was already a done deal.
Well, the Supreme Court, in
But
that
it was a
case,
dissenting only.
the Supreme Court in that case, gave the retroactive
Active
effect
effect.
of that law, even it is not a penal law. Because it has some penal implications.
Yeah.
Another one, kasi I heard earlier, it's about, you heard cases, VAUSI.
Yes.
Well, in 2001, this is what happened. So in a estafa case, the prosecution failed to present evidence that would warrant conviction. So the accused filed a demurrer to evidence. So the judge there, I'll go straight to the point. The Supreme Court said in that case, okay, the civil, in dismissing the criminal aspect, the civil aspect should also be dismissed. Okay, that was in 2012. 21, I think, in the case of spouses Wong. Recently, 2023, the Supreme Court made this decision. It involves VAUSI, particularly the economic abuse provision. So, Supreme Court said there that in the event there is a demurrer to evidence, no, and if it is granted, the trial court should not dismiss
The civil.
the civil aspect. So the question would be, why do you think there is a difference between those two cases? Does the other one, no, did the other one supersede, no, the other?
No, I think, especially with the Mendez case, it said that the acquittal does not necessarily result in the dismissal of the civil, unless the acquittal was because there was no ground for the civil liability itself to exist. So we divide it. Sometimes, in fact, before the CTA was warned that when you proceed to dismiss a criminal case, there should be a continuation or a finding or your ratio on the civil aspect. Because it can be that the civil, the burden of proof is different, that the civil criminal case is dismissible, but the civil aspect is not. So I would qualify my answer that the civil aspect can be dismissed if there were grounds for their dismissal, but not automatic. So even in the demurrer, if the demurrer is granted, well, of course, with leave of court, then the civil aspect can continue.
But do you still maintain, do you think the ruling of the Supreme Court in this case, with respect to estafa cases, that the criminal aspect should also be dismissed, of course, without prejudice to the filing of the civil case? Do you adhere to that one?
You mean that the civil aspect should also be dismissed
Dismissed.
upon the criminal? Not if
In
it was,
an estafa case?
not if it was, unless there was a reservation. In the BB22, you can no longer reserve. So the civil aspect is necessarily included. But with estafa, that can proceed even with the dismissal of the criminal. I agree.
Okay. So there are several economic provisions in our Constitution. So how do you intend to interpret them, Justice? Will you be favoring, you know that there is a provision under Article 2 about the natural resources should be effectively controlled by Filipino citizens. No? Meanwhile, we understand that we have to improve our economy also, thereby giving more leniency,
Yes.
no, to the investors. So how do you intend to interpret these economic provisions of our Constitution?
I think we should still run loyal to the provision that it will be control. And I guess that's the operative word, control. It doesn't mean barring foreigners from entering into industries, but control, ultimate control in the form of maybe the number of stockholders, whatever mechanism it is that you ensure that control is still with our citizens, then I think we should, my stand is that we can, in fact, rely on foreign participation, but with that caveat that the control guaranteed by the Constitution is always recognized.
So another question from the academy is, what is your understanding? This will be my last question. What is your understanding of transformative leadership?
Just my own interpretation of it. It's leadership that does not stop with what is required from your obligations and duties, but harnessing that leadership to bring about social change and social justice, especially when needed. I think that has marked my career in the judiciary, that I don't limit myself to purely adjudicatory functions, but I go outside of my way to do things like judicial education and judicial reform to bring about some positive transformation.
So how can you inspire the members of the Supreme Court, the other 14 members of the Supreme Court, given the fact that you are the most junior Associate Justice? So how are you going to show or display this transformative leadership?
I think in a very, not immediate, when I did that when I was a new member of the CTA, I always give due respect to collegiality. In the back of my head, I always give respect to the seniors. But very slowly, I think even because when I started out in the judiciary, I was very young. They said, tumanda na nga talaga ako. I think I have a way, they say it's my charm, that I'm able to convince them of some transformation. And I'm always very inclusive. I volunteer my services, not as the leader, but respectful of, you can be my chair, but I'm gonna ding, I will help you in this committee. And I think in the committees I've joined, where I've worked with justices like Chief Justice Peralta, Justice Ben, even Chief Justice Esmundo, they know that I can be relied upon, and I'm not very aggressive to push what I want, but I try to see what their advocacies are, and I try to volunteer what I can do in those specific aspects. I think I have a balance of passion and emotional intelligence in that respect.
Thank you, Justice.
Thank you. Thank you, Your Honor.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Good morning, Justice.
Thank you very much, Attorney Marife. Good morning, Justice.
Good morning.
I represent the retired justices of the Supreme Court. Ganun ba? Wala. I represent the retired justices of the Supreme Court, and I have sets of questions here from them. And with respect to my personal questions, I will just interject them. As for the other questions, they were already covered by my two colleagues, so I'm just adapting them. I'll start first with Justice Ascuna. In what ways have your present position prepared you to be fit for the Supreme Court? I heard you earlier regarding this, but if you want to add more, you can.
Thank you. Thank you, Justice. As I said, my 31 years in the judiciary have been marked not just by, I try to be excellent in my adjudicatory functions, but I did so much for judicial education, not just locally, but also internationally. I think that I have worked with judges who've appreciated what I've done. I'd like to include that because I have first-hand exposure with the judges. I know their problems as being a judge myself. In education, their all clamor was always, help us simplify our procedures. And that one I'd like to really follow up on. One of the best compliments given to me during my lectures was that I remember giving a lecture on securities on the SEC, securities regulation, etc. And sabi ni Judge Suarez, I remember, she goes, yun lang pala yun. Law school pa lang ako, hindi ko na maintindihan yung mga stocks na yan lang pala. Because, and I remember Professor Dicini saying that when I lecture, he says, I dumb it down. I don't take it as an insult. I really want to help judges understand the basics of the cases that come before them. So that's one. I'd like to think that my experience, especially with the Philippine Judicial Academy. The Judicial Academy has given me so many opportunities. Starting, I used to lecture a lot, but now I've graduated to developing curriculum. In fact, we have one, my current curriculums now for training. At the end of the month, we had one in cooperation with the Korean government for competition law. As I said, we have one for the WIPO. And then aside from judicial education, I also have been so involved in judicial reform. You've seen from my PDS the many committees I've joined, but at present, the ones that are pending and that I've finished is in line with the Chief Justice's move to simplify procedures and to limit case docket. I was the chair of a committee that made drafts on rules on filtering mechanisms, which now require that before cases are filed, there are two modes of dispute resolution that have to be resorted to. And the one that I'm presently doing now is a manual for WICL, Women in Conflict with the Law. We're giving two documents, one where the receiver would be the women in conflict with the law itself. Again, I adhere to that Q&A format. So it's very yung question doon, pagdating mo sa presinto, anong unang gagawin sa'yo? Ano ang mga dokumento na dapat nandyan? So ganun kasimple, no? Because a lot of detainees go there not knowing. So ano yung dapat, so sasabihin sa kanila, dapat meron silang makatawag ng lawyer, ganyan. So those are, aside from that, I think my work, even in the law office, gave me a chance to hone my writing skills. My work with the MTC, with the many challenges brought there, showed me ways to expedite cases. Imagine we had 4,000 cases before. We didn't have the benefit of the, which is now being used by the MTCs. So I had to do so many things to expedite cases. And in the RTC and the CTA, I was given the opportunity to be an expert in many fields. So that one, called from all my experiences in that, I want to bring that and continue always, I think, why I want to apply now with the Supreme Court is to continue that service. I want to give I know it sounds corny, but I really want with the justices to give the judiciary the good name it deserves, always with excellence and integrity in mind. I hope that that answers it, Justice Mendoza.
Okay, Justice. You said you want to continue rendering such service if you reach the Supreme Court. The second question is, what should the Supreme Court be doing differently and why?
Right now, I am so appreciative of the SPJI in particular, and I think the challenge there is to see them come into fruition. I don't think they know already the problems that confront the judiciary. They have good systems in place. The problem now is execution, and I think that one, again, looking at other political experiences, sometimes maganda na tapos ina-abandon. When I enter, I don't wish to, I want to work on what has been started by the giants who are already there. What the Supreme Court is not doing, perhaps, not doing but not yet achieving, is seeing all these good policies into fruition, into action. And that's where I think I can pour my resources and my help in, to see that all these wonderful innovations are put into place. Maybe also, as a former judge, I would spend more time also having, seeing really what are the small problems being encountered by our judges. I know sometimes, because you were in the Supreme Court already, we are far removed from the day-to-day workings of the judges. I don't know if this is still true, but during my time 6 years ago, we had very common problems like, okay, you talk about interconnection, digitalization, but we didn't even have landlines. Our landlines were not working in Pasig. We didn't have enough bond paper. So those are little things that could really be addressed if there was a system in place that was that was professional. I would like to say that in the CTA, it was such a wonderful experience because everything was so smooth. I needed a trash can. In 2 minutes, the trash can was there. Yeah, and I think because it's a small office, we're only 9, and then the justices before me already had systems in place. The departments were so well organized. But minsan ho nakakaawa talaga, and I've been with the MTC and RTC. I admire them for how they render their duties with such meager resources. Although now I understand that mas madami na. They're being addressed. Maybe that, I'm not sure if that is still the case now, but perhaps more direct interaction with the lower courts.
Thank you very much. The next question comes from Justice Abad. What rule generally governs the interpretation of laws when applied to actual cases?
Again, each case, you always go to the Constitution. How the law, that's the first step, no? And then after, given the facts and the evidence before you, varying rules, whatever law and jurisprudence is applicable. And then you have policies like, depending on what is before you, is it a strict interpretation or a relaxed interpretation? There are many factors in play when a case is before you.
Are you an originalist?
I believe in a living constitution, Justice.
What area of the law do you feel you can immensely contribute to in its development?
Well, because my expertise has been in commercial, that and family, and chiefly those, and remedial law, because I with my many committees in judicial reform for the rules. In fact, now I'm the working chair of what Chief Justice has called, hopefully, we call it the legacy. There is a move now to consolidate. We call it the Committee on Pleadings, Practice, and Procedure, where the ultimate goal is to have all the rules found in one physical compendium and in one online compendium. This came about because like young lawyers and senior lawyers already don't know. Sometimes there's so many rules. Like adoption, may rule pala na ganito. You know, when you're, not all lawyers are generalists, no? Sometimes they don't know. They have to pre-refer my court. Naawa naman ako because counsel, there is a rule. They don't know. And you can't blame them because there are just so many rules now confronting litigants. So the role of this Committee on Pleadings, Practice, and Procedure is to get all the rules in one compendium. If you can imagine it, it's a ring binder folder where all the rules will be there. What we did is we made subgroups. Like for instance, in the CTA, you also know that because some rules, like the original rule that we made on IP, will contain even provisions on answer, pretrial, etc. What we're doing here now is we're trying to make all the rules have one common, and then when you specialize, wala na yung, let's say, IP, wala na yung complaint, pretrial, etc. You will only have the provisions relevant to IP. Same with the rules on FRIA, same with the rules on adoption, etc. And all these rules, ideally, will be in one compendium, a physical one. And then, we looked at the model in the US, even online, you will have one website where all the rules are there and there are links. So this will be really so helpful for all the litigants to have that. We've started it. I took part of the subcommittee on commercial and CTA. In the CTA, in fact, we have this maverick suggested by Chief that we will already remove the unbanked adjudicatory powers. It will be, because that's unusual only for the CTA. The CA and the SB, they only have divisions. And from the divisions, they go to the SC. Here in the CTA, from the CTA division, the decisions can go to the unbank. And we looked at the data, sometimes less than 6% are overruled because you already have 3 of the 9 ruling that way. So you only have 6. It's very unusual. Of course, it can be that the 3 will change their minds. So it's just 6%. So we're doing this in that project for pleadings, practice, and procedure.
That is very good. I've been reading so many rules,
Yes.
so many agencies,
Yes.
and I believe that they should be placed in one compendium.
Yes. And make it, we're trying to make even the rules of each part just counter-refer to the main rule, the rules of procedure. So each specific rule, wala nang pre-trial, wala nang complaint. It will go directly to what is relevant na lang to that. For instance, in CTA Justice Uy, wala na ho yung pre-trial, etc. We will just go, for instance, to retain yung motion for suspension of collection of taxes because that's particular to CTA. But everything should be uniform wherever you are.
I think you can answer this. You're a commercial court judge. What proceedings have you encountered which is very unique to that law, which you cannot find in any other laws?
In rehabilitation.
Anything, na very unique lang, you cannot find it
Oh.
in other rules.
I like, in intracorporate dispute, I like those very summary because they're very useful. There's one there on election contest. And in election contest, it has to be filed within 15 days from the election in the corporation. And then they don't even come to court. It's all by pleadings, and then you don't meet them. And that one, it gives immediate relief. Because that's common among corporations that they have this struggle for election. What happens is, if you don't file your election contest within 15 days, you can no longer question.
Any other rule? Unique rule.
For rehabilitation, it's unique because it's not like your usual case where it's adversarial. So I like that because it gives me such a proactive role. We meet them, all the persons involved, the creditors and the defendants. We go and do ocular inspection to the site of the company. I remember one, it was they were doing computer chips, and that gives you a different perspective because makikita mo talaga that these people are working, there's a product, and sayang naman because of some form of malas, they cannot continue. And then it's also nice that this gives you a chance to directly consult with the stakeholders. And then the ultimate rehab plan is really a joint effort between the parties. It's not like a regular case where it's adversarial and then they don't cooperate. This one, it's a give and take, more like a dispute resolution sort also, but in a very professional manner.
Where do you find the procedure nolo contendere?
That's one of the, I'm not good with Latin phrases.
Oh, I thought alam ninyo. Sa anti-competition law.
Anti-competition,
Yeah,
okay.
It's very unique. You cannot find it in any,
any.
other law. Maybe you can adapt that for the other,
Yes,
the other rules.
This May, I helped draft a training program for anti-competition, but I've never handled competition. So I'm joining their training just to because I'm in the commercial law department. So I will look out for that, Justice. Thank you.
It's very unique, but in this stage,
May I hear it again, Justice?
I will now go to the questions of Justice Brion. Question number 1, is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why, and explain fully.
More legal,
Okay. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why, and explain fully.
okay. By virtue of his office, the Chief Justice and the other associates of the Supreme Court, their primary duty is really to interpret the law. While the executive, the president's primary duty is for execution of the law. So I would say that the impact of the Chief Justice, and not just the Chief Justice, but the other associates, would be more than that of the president. While the president has veto powers, ultimately, the law is living and the Supreme Court as the final arbiter of all legal tussles will, by virtue of their very office, they have more influence in the interpretation of the law because that is precisely what defines their office.
Question number 2. Is there a difference between strict scrutiny and strict construction? Explain.
From the nomenclature of the words, I would say there's a difference because scrutiny would mean analyzing and looking at what is applicable based on the facts. And construction would mean whether you give it strict or liberal construction. Construction would mean your ultimate treatment of the issue, whereas strict scrutiny would mean how you would go about in analyzing and applying the law and jurisprudence to the given facts and evidence.
Strict construction refers to legal hermeneutics, and strict scrutiny is a standard of judicial review. So you're correct there. Question number 3, explain fully the concept of protected speech and unprotected speech.
Protected speech are those where the courts cannot impose prior restraints. It's found in the basic right or constitutional right to free speech and association. And the other one, Justice? Unprotected speech are those that impinge on the other rights of the citizens. For instance, libel would not be protected speech. Now, the very common would be fake news would not be protected speech.
All right. What are the 2 elements of the freedom of expression?
Freedom of expression, number 1, that the people are given the freedom to express their sentiments and ideas as long as they do not impinge on the right of others. They do not, and also that these do not threaten public security and safety.
Better to, how about the aspects of two aspects of the freedom of speech?
Of the, sorry,
Freedom of speech.
again, the freedom of speech entails that persons have the inherent right to express their opinions as long as they do not impinge on other rights of equal other rights of the citizens. Like freedom of speech will not give you the license to irresponsibly give a false information that will cause or affect the security and reputation of others.
The answer there is there are two. One is freedom from earlier restraint, and what
Prior
is the
restraint.
other one?
Prior restraint and the other one is after the fact. Prior restraint
freedom
is
from-
to prevent it from the very inception,
Yes.
and after one is censorship after it is expressed.
What do you call it? Subsequent
Subsequent.
punishment. Freedom from subsequent punishment.
Okay.
I go now to the questions of Justice Tiham. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer. If the answer is yes, give examples of procedural grounds which you think are reasonable grounds for acquittal.
Acquittal. Well, number one is double jeopardy. If they have already been, if they have pleaded and they've been convicted, they've been acquitted, then that's a procedural ground. Another one is if the qualifying circumstance is not there, then they cannot be convicted of the crime as charged. Fruits of the poisonous tree, or if the evidence against them was illegally obtained, again, that can lead to their acquittal. Heinous crimes.
Really is, would you consider acquitting a person accused of such heinous crimes based on those procedural grounds which you mentioned?
Well, the right to due process is a constitutional right that cannot be sacrificed just because a crime has been committed. And let's say it was, and I've known of heinous crimes where there have been acquittal because of some procedural grounds. I think the remedy there is to bring them to court for the civil aspect, and also to bring administrative charges against those that brought about the procedural infirmities. But I believe that it cannot, especially if the violation of the due process clause was instrumental in changing the verdict. Procedural grounds are there to ensure they're not just empty rules. Some of them lie into the very rights and are tied up with the very integral rights of the accused.
So you're willing to acquit a person based on procedural grounds? Yun lang naman ang tanong.
Pag ano ho, pag talagang there can be there can be instances when you can overlook the procedural grounds. There's something I read about when there was a lapse in the decision writing, and that was called to be a void judgment because of something that was not there, then acquittal follows. I think instead of acquittal, is that nunc pro tunc, that you can, instead of acquittal, let the trial court complete its decision by providing what was omitted. That's a procedural omission that instead of proceeding to acquittal can be corrected. So my answer is, if there are means to correct the procedural infirmity, then I will pay more attention to the seriousness of the crime that has been committed, especially if the evidence is already strong.
Okay. Thank you. Okay. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation?
I agree. I agree, Justice, because it will, in the decisions of the Supreme Court can have such far-reaching effects on individuals and institutions. But at the same time, that being said, those individuals and institutions should be forewarned that the Supreme Court can, in fact, be stern in its application of the law.
The next question is, if you know only, in the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice?
The citizens. May I know, Justice?
U.S. Solicitor General.
Oh, that is
Justice-
not true in our
Justice-
jurisdiction.
Justice TEEHANKEE provided the answer. Yes, it's not in our jurisdiction.
Yes, that is not true in our jurisdiction.
But if you're from the Supreme Court, there is a 16th justice. But I will not name him here. You're not from the Supreme Court.
I am curious to know that.
Okay, again, U.S. Supreme Court. Only if you know, what is the doctrine of the rule of war adopted in the U.S. Supreme Court?
Sorry, I have to say I have no idea.
Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
Maybe not vehemently, but there is one that comes to mind. It's the recent decision in Kirit. I'm not sure of the complete title, where the Supreme Court ruled that only the innocent spouse can have the bigamous marriage declared invalid. Because in my opinion, the Supreme Court in that decision in fact said the bigamous marriage is invalid. It doesn't change the invalid nature of that bigamous marriage. But still, it went on to say that only the innocent spouse. But for me, I don't think it should matter who should file, because after all, it is already void. Let's remove it from the possibility of having that non-guilty spouse face administrative and criminal penalties. But as to the petition, to have it declared void, because it is already void, in my mind, to my mind, it doesn't matter who among the spouses will have that particular bigamous marriage declared void. In fact, that decision, I think there were two dissenting opinions.
Do you agree with the decision that there need not be a declaration of nullity before you can file an action for?
I think there should be a declaration of nullity just so that for order. And then the nullity should not be presumed.
Yes, so you disagree with the Supreme Court, but not vehemently.
Not vehemently. No. There should be, because it said there that there should be a declaration of nullity. It's just that their ruling was that it cannot be the innocent spouse, the guilty spouse who should file for the declaration of nullity.
There is a subsequent decision saying that there need not be,
Oh, a declaration of nullity.
because you were in the CTA, maybe you were not able to read that.
But this was quite new, the Kirit. I think it was just last year or this year. Yes,
So I
po.
cannot blame you for that because you were with the CTA.
Because that came side by side with the other decision that I found also maverick, in that they can say that's judicial legislation. Yun nga hong that the Filipino spouse can remarry even if it was the alien spouse who obtained the divorce.
That is the Manalo case.
Yes, the Manalo case.
Okay, how about the Aquino versus Aquino case?
Well, that is also maverick in the sense that the law is clear in one hand, but the other law was used. So it's a matter of, if you're in the Supreme Court, you can really use different laws to support your position. But that has been the Iron
Was the
Curtain law, right?
Yes.
Yes.
The Iron Curtain Rule in succession.
That
Is Article
non-marital.
92. Oh,
Yeah.
yes, 992. So,
But-
what do you think personally? Is it a judicial legislation?
I think maybe in doing that, because there was merit in the ratio decidendi, that certainly, especially now with the considerations given to non-marital children, but maybe there should be been a reference to perhaps, I like that, let the legislation take a second look at it for purposes of clarity. It's not saying that we're wrong, but to clarify and to be consistent with this ruling, perhaps the legislation can look into that law that clearly stated that Iron Curtain law.
Why do you consider it judicial legislation?
Because there is already existing legislation that very clearly on its face covers the situation. But then,
Was the was the article amended?
no. That's why it was a reference to, instead of that article, this article is more applicable.
So what article was that?
The 9, I'm not very familiar, 92, the other one was 924, the other one was 92. I'm not sure of the numbers,
it is
but there were two.
It is 982.
Yes.
Yes,
So
982.
perhaps
Can you
that
not call
way,
it judicial activism?
yes, but not maybe judicial. You can remove
Legislation.
yourself from judicial legislation because you didn't touch on that. You just said that this is applicable. So it's a matter of looking at the interplay between two seemingly contradictory laws, but saying that this is applicable. And that gave it, that supported the ratio.
In the Valenzuela case, it was stated that in criminal law, intent to commit the crime is different from intent to perpetrate the act. What is your understanding of that, and how did it come to be? How did it come to be?
The
What
difference
was
is
the
very.
thinking of the Supreme Court?
I didn't encounter this, Justice, but could you give me the facts and maybe I can derive the reasoning?
It's simple only. They just they just stress that the difference between mala in se and mala prohibita, and they said that, and the rule is that you know it, that it's very basic. In mala prohibita, intent is immaterial,
Yes,
so you need not prove intent.
yes.
But in that case, in Valenzuela, it was a mala prohibita case. But still, they said you have to prove
The intent.
there was intention to perpetrate the act, to be guilty. So, what can you say about it? Intent is immaterial, but you still have to prove the intent to perpetrate the act.
Again, it's curious, but perhaps in that particular situation, is that one of those that the facts are only and the ruling is only applicable to that case?
It was not pro hac bis.
It was not. The criminal cases that I encountered, if it's male in se, there's no question. But here, if they still wanted to find out the intent, I would venture to say that it would just be to confirm the guilt of the accused.
Okay. You were a family court judge.
Yes.
Yes. Psychological violence due to marital infidelity. That is penalized under BAUSI. BAUSI is a special law. Is psychological violence due to marital infidelity mala prohibita or mala inse?
Oh. Inse.
Inse, can you explain? It is a special law.
It is not the special law is that the causing of the damage is that what is prohibited. It's the causing. But the manner of causing is not provided for under the law. There can be different ways. In fact, if I remember right, that ruling is quite new, that marital infidelity is in fact now considered a form of psychological violence. So there, I think then the intent can be looked into, because what is really punished is the act of causing the psychological or emotional or material financial violence.
So you prove not only actus rea, but what? And also the other,
the intention.
mens rea. Oh. Thank you very much, Justice.
Thank you.
That will be all.
Thank you, Justice
Your
Mendoza.
excuse.
Thank you. Thank you, Justice Uy, Attorney Fairman, Justice Mendoza.
Thank you, Justice Mendoza, and thank you, Justice Maria Rowena San Pedro. Your Honors, the last candidate to be interviewed this morning is the Honorable Court of Appeals Associate Justice Walter S. Oong. Good morning po, Justice Oong.
Good morning, Your Honors.
The first to interview Justice Oong is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Oong. Go
Good
ahead
morning.
and drink your
Good
water.
morning po. Thank you.
You have been with the Court of Appeals for more than 7 years.
That is right po, Your Honor.
Would this be your first time to apply for the Supreme Court?
That is right, Your Honor.
In your more than 7 years in the Court of Appeals, is there any significant case or legal decision you rendered which had a profound impact on you?
My position, Your Honor, has always been that every case is important in the sense that these are not just nameless individuals who are before the court, but rather they are actual persons, actual lives. So I treat each case with equal importance. Having said that, Your Honor, if the question would relate to a specific case,
No need to mention the title of the case.
yes, Your Honor.
Just the impact that it
The
had on
impact.
you. Maybe the
There-
issues or whatever.
There is one case, Your Honor, that had a significant impact in me in the sense that I was placed in a dilemma because I was uncertain if I should take into account my personal observations because I felt at the time that applying the law might be too harsh. But at the end of the day, I felt that I had no option but to apply the law because that is what I am called upon to do.
Where did the dilemma arise?
This case actually involves I will try to make it as general as possible, Your
Yes.
Honor. This case involves a public official who was charged with grave misconduct because the public official received something in exchange for the services that is required of the public official. I found that, or to my mind, the so-called consideration is actually minimal. It would seem to be a token appreciation, but nonetheless, take into account the discussion of the lower agency, they simply applied the law. So, factor in also other considerations that were present in that case. I eventually arrived at the conclusion that, first and foremost, I really need to apply the law. So I had to set aside my personal dilemma and eventually affirm the ruling of the lower agency.
What qualities do you believe are essential for a Supreme Court justice, and how do you embody these qualities?
I believe that it is essential for a Supreme Court justice to embody the qualities that are enumerated under the law and in the Constitution. They are essentially independence, integrity, probity, and of course, accountability. I would like to believe strongly, if I may say so, Your Honor, that for the past close to 8 years, I have been independent. I am proud to say that no one has ever approached me, and I am glad that it is that way. I have always been impartial also in the rulings that I hand out. And another thing that I think is very important is the recognition that what we have is a collegial body. So there must be a willingness to accept opinions from other parties. Not parties, but actually other magistrates also. And there must also be that willingness to dissent if duly called for. Finally, I think that it is important for a justice to be humble, to be always grounded, and a recognition that he or she does not know everything, and that there is always this constant need to keep himself or herself abreast with the changes or updates in the law.
Your current ranking is, you're the 25th in ranking?
In terms of ranking, I am the senior member of the division of the court, but that would be 21, 17 plus
Anyway, I
6
got
is
this from-
23 plus, because there are
So
other
you have-
justices from the Cebu station and the Mindanao station who are actually more senior than I am. So I believe around 25, Your Honor.
And you are now a senior member of a division.
That is right po. I'm the senior member of the 6th Division.
I see. It appears that you passed the New York State Bar examination. Did you have the opportunity to practice your legal profession abroad?
I took the New York bar exams in 1996 after my studies at the University of Pennsylvania. I decided to take up the New York bar as an option. But eventually, I opted to come back and to pursue my private practice here in the Philippines, Your Honor.
So did you have the opportunity to practice in New York?
Oh, I was not able to, Your Honor.
So you just decided to come back.
Yes, that is right po.
When did the inspiration to apply for the position of Associate Justice of the Supreme Court entertained in your mind?
I believe that a seat in the Supreme Court is the dream of every lawyer, po, Your Honor. With the training, the experience, and the exposure that I've had for the past close to 8 years with the Court of Appeals, plus the decades of law practice before that, I feel that I am somehow equipped already, Your Honor, to be able to take on the greater challenges that is required of a magistrate of the Supreme Court, Your Honor.
It is reflected in your PDS that you voluntarily inhibited in 31 cases.
Oh,
May I
okay.
know the reason or reasons for your voluntary inhibitions?
These cases would involve, some of them, number one, would involve the OSG, in which my nephew is one of the handling solicitors. Others would involve cases in which the party or one of the parties is a former client of the law firm I was previously connected with. Others would involve cases in which the law firm involved has my nephews or nieces as one of the associates or lawyers in the law office. Oh, and recently a former law partner in the law office was named as an NLRC commissioner. So now I find the need to also inhibit in cases in which he signed or participated in the NLRC case, Your Honor.
If appointed to the Supreme Court, how would you approach a complex legal issue with multiple potential interpretations?
When called upon to interpret the law, I find myself taking into consideration real-world scenarios and societal needs. I think it is important to consider the actual impact of the decision that I will come up with on the lives of the people. At the same time, Your Honor, I think that pragmatism must be tempered by a respect for established judicial precedents, so much so that we do not undermine the stability of the law, Your Honor.
Have you in any way been affected by public opinion?
I have not, Your Honor. I feel that a judge, no matter how harsh or no matter how adverse the public opinion or opinion from the public may be, should not in any way be affected because we are called upon strictly to apply the law. That is our training, Your Honor.
Considering that the Court of Appeals is a collegial court, have you encountered a situation wherein you disagreed with a colleague on a legal issue, and how did you handle the disagreement?
Yes, My answer would be in the affirmative, Your Honor. There had been instances in which I disagreed with the views of a colleague. There are times in which the disagreement was eventually ironed out, either with me accepting the contradictory view of my colleague or the other way around. But there had also been instances in which I found myself being constrained to come up with a dissent. But in all of this, there is always a discussion that takes place, and there is always this recognition that I should always take into account the views of my colleagues.
What are the instances when the court may still pass upon the main issue, although the case is already rendered moot and academic? Or the issue is already moot and academic?
As a matter of rule, or generally speaking, a case must be ripe for adjudication. There must be basis or reason for the court to decide the case. And if it is already moot and academic for the court, usually the
Exceptions
proper
to the
course
rule.
of action
Yes.
is to dismiss. But the exceptions would be if the issue involved is of transcendental importance, if it is possible to recur again, and if it is necessary to guide the bench and the bar. Those, I think, are some of the exceptions in which the Supreme Court would continue to rule despite the issue having been already considered moot and academic.
So if appointed, you will follow these exceptions.
Yeah. Opo, Your Honor.
A law is passed which provides that when the Department of Public Works and Highways expropriates property for government infrastructure projects, it will have the sole and exclusive authority to determine the price to be paid on compensation to the landowner, which amount shall be no more than the assessed value of the property used for real property declaration. Is this provision of law valid?
I think that provision of the law may be subject to question because of the outright authority or discretion on the part of the DPWH to determine the actual amount that would form part of just compensation. The rules on eminent domain with respect to expropriation require the payment of just compensation, and just compensation is a matter that is up for the courts to decide, to determine the justness of the compensation that is due to the property owner.
Yes, so it's a judicial action that must be, yes, it must be rendered, not the DPWH.
Opo, Your Honor.
Yes, you're correct.
Thank you.
The House Committee on Peace and Order conducts an inquiry in aid of legislation into alleged death squads and vigilante groups of the Philippine National Police in an alleged informal alliance with the CPP-NPA. Implicated are high officials of the palace. The House Committee summons the DILG Secretary to appear and testify. However, the Secretary refuses to appear and testify, invoking executive privilege. May the Secretary be compelled to appear and testify, and why?
I think that the Secretary of Justice, in the case that you just mentioned, Your Honor, may be compelled to testify.
It's the DILG Secretary.
Oh, I'm sorry. Yes, sorry. I stand corrected.
Yes.
Sorry po. I
Yes.
was actually referring to the DILG Secretary. My apologies. I think that it is something that would be in aid of legislation if, assuming that that is the premise of the Senate or the Congress, then the DILG cannot invoke executive privilege, Your Honor.
Would you know who can invoke executive privilege?
Executive privilege may be invoked. I'm sorry, Your Honor. It somehow escapes me at the moment, but
Senate
Ano?
versus Ermita. Only the President or the
President.
Executive Secretary
Yes.
by
Okay.
authority of the President in writing can
Thank you, Your
invoke
Honor.
that privilege.
Thank you, Your Honor.
Are you familiar with the rules on electronic notarization?
I haven't gone over the rules and the guidelines, but I am aware that the Supreme Court had already passed the rules on electronic notarization.
So you have not gone over the rules.
Unfortunately, I have not gone over the rules yet, Your Honor.
What about Data Privacy Act of 2012? What crimes are covered under the law?
Data Privacy Act. Data Privacy Act was passed to ensure that privacy of individuals with respect to the gathering, collecting, and storing of information will be respected, and at the same time ensuring that the flow of information would not be hampered. Your question, Your
What
Honor,
crimes are
relates
covered? So how is violation
Crimes.
committed?
can be violated by individuals or any entity that would be responsible or have as part of their functions the collecting, gathering, and storing of data, Your Honor.
All right. There are 9 ways of committing it. You can just review the Data Privacy Act of 2012.
Thank you, Your Honor.
Corporate law. I'm sure you're familiar. You're an accountant, and you're a board placer. Have you had the opportunity to practice your accounting profession?
Immediately after finishing college, Your Honor, I proceeded to law school, and the results of the board exam came out while I was in law school. The only opportunity I had to somehow practice accounting was when I was invited to teach while in law school. I had the privilege of teaching accounting subjects, basic accounting, partnership, corporation, and financial accounting for 2 years while in law school. It is only to that extent that I was somehow able to practice the accounting side of my profession. Although initially when I went into practice, I had an interest in taxation. So it's only to that extent po, Your Honor.
Why did you not apply with the tax court, given your qualifications, if I may ask?
My first application actually was much earlier, and I actually applied for a position in the Court of Tax Appeals.
What year?
It was during the administration of President Aquino. I cannot recall, Your Honor. It must be sometime during 2014 or 2015 po.
In your PDS, it is shown that you have been in private practice. What cases have you handled as a private practitioner?
I had been in the active practice of law up to the time that I was appointed. I was connected with a law firm for 5 years, and thereafter, I put up my own law office. My active practice in law involves litigation,
What
both
fields
civil,
of law?
corporate law, intellectual property law, labor law, and real estate transactions.
So you're very adept in these fields?
I hope so.
What is the test to determine whether a case is an intra-corporate controversy?
An intracorporate controversy would involve actions in which
There are 2 tests, if you know.
uh,
Or you can describe.
if it involves it's funny because I have had a lot of intracorporate disputes before.
Yes, I'm
but
sure you would analyze if
Yes.
it's intra-corporate
Yes,
or
yes,
not.
Your Honor. If it involves actions between stockholders,
Correct?
if it also involves if the action involves the rights of stockholders,
So it's the
sorry.
relationship test and the
Relationship.
nature of the controversy test. I'm
Yes, that
sure
is
you
right.
know that.
My apologies, Your Honor. Thank you.
What are the two tests for a valid delegation of legislative power?
It must be complete.
Yes.
There must be guidelines
Yes.
and basis for the delegation. And it must be reasonable.
Yes, that's correct.
Thank
Uh,
you.
One last question because the
Apo.
red light is on. What are the twofold aspects of right to religious profession and worship? What
Religion.
right
To-
can they exercise?
I'm sorry,
When
Your
they
Honor, can
invoke
you-
the right to religious profession and worship, what
Mhm.
does it involve?
It
What
involves
right
the,
is
it
involved?
involves the freedom to exercise one's own belief, and also the freedom to choose not to do certain things based on religious beliefs.
Freedom to believe and freedom to act on one's belief. So that's my last question, Justice
Thank you
Ong.
po. Thank you po,
Good
Your
luck to
Honor.
you.
Thank you, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nezauro H. Firme.
Thank you, Attorney Marife. Good morning, Justice.
Good morning po, Your Honor.
So how did you prepare for today's interview?
I tried to sleep more last night. I also tried to review
Yes.
the past few days. Emphasis po on the try.
Good thing you answered first sleeping before studying. That's the best answer.
Thank you.
Okay. Justice, no, if appointed, what can the stakeholders expect from Associate Justice of the Supreme Court, Walter Oong?
The stakeholders can expect more of or the same thing that I have been doing with the Court of Appeals. That is to be independent and to always see to it that I apply the law fairly and impartially.
So you were, before joining the judiciary, no, and for almost 12 years, you were the managing partner in Oong, Meneses, Gonzales, and Gupit. Okay, can I go there?
Opo, Your Honor.
Can I go there in the Gupit?
Opo.
So why only now that, why only after 12 years na you decided to go into the judiciary? Di ba
Yes.
it's too
It's-
long?
Hindi po. I feel that at the time when I applied, that was when I felt that modesty aside, that I already possess the necessary qualifications, foremost of which is the competence. I felt that years of training would be necessary before one can assume the position of an appellate court justice. And at the time, I felt that it is already sufficient.
So you are on your 7th year here in the Court of Appeals, correct? Going 8th.
I'm on my 8th year
Yeah.
po, Your Honor.
Yeah. So to what extent do you adhere to the principle of seniority?
Within the court,
Yes.
it is...
To what
it-
extent do you agree? No?
It is
Of
the-
course, some would not agree on it, no? Because we are all created equal, and there is no such thing. There is no such thing as substantial distinction between and among associate justices of the Court of Appeals. So, to what extent do you agree or to adhere to this rule?
It is a tradition in the Court of Appeals, in the appellate courts, and also in the Supreme Court that seniority is always observed. But seniority, based on the rules, would apply only with respect to, or precedence would apply only when it comes to certain events during the en banc session, and in determining the division memberships. But other than that, a junior member or the most junior, even the Benjamin in the court, has an equal say, has the same functions and duties as the most senior in the court. So I think that while there is a need to respect seniority when it comes to decision making, which is the principal function of a justice, seniority should not be invoked in the sense that it cannot be used to try to influence the vote of the more junior justice.
You took the bar in 1997, Justice, no? And then after graduating in Ateneo in
1993.
1993.
Apa.
So, why did you not take the bar immediately? I understand you have to go to...
Your Honor, I actually took the bar immediately after graduating. It's just that I was only allowed to take the oath close to 4 years after because I was involved in a minor altercation while I was in law school. Actually, that happened after I graduated already.
You're already a graduate. When
Yes,
you
Your
got
Honor.
involved.
Yes, Your Honor.
Sige. I'll ask you about that later on. No?
Okay.
It's one of my questions.
Opo, Your Honor.
So you are the brother of then Sandigan Bayan Justice Gregory Oong. So what similarities and differences do you have with him?
My Kuya Greg is 15 years older than me. So I treat him like a second dad. Our father passed away when I was a sophomore in the law school. Speaking of law school, my Kuya Greg was a big reason why I decided to enter law school. I would hear stories about the cases he handled at the time and how he was then in a position to help others as a lawyer. So this inspired me to take up law. And since our dad was no longer around, he would always be there to guide me, always stressing that I should always do good, be honest, and be fair in all my dealings. When I became a lawyer, I would hear the same constant guidance from him. Work for him was always a priority. He would always be in court before 7 in the morning, and he would go home late. That was how he viewed work at the time. When I was practicing already, and I had my own law office, I was told not to take up any case that is pending before the Sandigan Bayan because he never wanted me to take advantage of his position. So I never did accept any case that was before the Sandigan Bayan. Those who know him know that that is how he is. And I know that that is who he is. Those constant reminders that I get from him and the work and moral ethics are what I constantly adhere to, and I hope to continue follow as I continue my career in the judiciary.
Any difference aside from, I think your brother is much bigger than you.
Yes po.
Okay. You are a stockholder in 15 corporations, Justice. So
Yes
what
po.
business are these corporations into?
These are all family businesses. Actually, some of them have already, the businesses covered by some of the corporations have already ceased. But I had to include them because I am under obligation to disclose all shareholdings that I have. But with respect to those that are still operational, some of them are holding companies. They hold properties owned by the family. Some are corporations that run gasoline stations.
So you are a member of Fraternal Order of Utopia,
Yes,
a
po.
Knight Commander of Rizal, and Mason of the Philippines. So if you are to rank these three brotherhood, which is the closest to your heart?
I am a member of all three organizations, but truth to tell, I am not that active in the three organizations. I became a member of the Fraternal Order of Utopia when I was still in law school. That was in 1989. I became a member of the Freemasonry. That was in 1995, and I became a member of the Knights of Rizal when I was in the court already. In all three organizations, I was never an officer. But to answer your question, I think my heart is closer to both Fraternal Order and the Freemasonry.
So, in relation to that, you know what I'm going to ask you about the case you had? Is that the one?
Oh,
In
opo,
relation
opo.
to Mark Halandoni.
Yes, that is right, Your Honor.
So what
It was-
happened during that time?
I had
You're already
I
a graduate?
already, yes,
A
yes po, Your
graduate of-
Honor. I graduated already.
you were reviewing for the bar.
That
I
is right.
suppose.
That was during the review period. I distinctly remember that I had just gone out of the library. I was still holding my law books at the time. When I got out, there was a minor scuffle. Nagtulakan lang po. And then I had to rush in the same way that others who were within the vicinity rushed to see what was happening. And immediately, people tried to pacify already those who were involved. And that was it. But somehow, someone identified me and my other fraternity brothers, and we were all charged. And the funny thing was that the charge was for frustrated homicide. But of course, nothing came out of it. And even at the preliminary investigation stage, the case was already dismissed, as far as I was concerned. But because of that, I was barred by the school from attending review classes, so I had to review on my own. And the decision of the Supreme Court allowing us to take the bar came out the Tuesday before the first Saturday, or before the first Sunday of the bar exam.
Justice, during that time, what did you do? Diba, from the time you
I was
took the
busy
bar?
reviewing on my own.
No, I mean,
Your Honor.
after the bar examination, no, it was, I suppose, sometime in September pa ba? During your time, September of
Septem-
1993.
That is right po.
What did you do thereafter? Because
I
you became a member only in 1997, save for the fact that you went to Pennsylvania.
I was with a law firm in Makati. So I was taking in effectively as a legal intern. So I was exposed to the various fields of law for a period of about 3 years before I was allowed to take the oath. And I also found it was an opportunity for me to take up further studies. That is why I decided to take up further studies in the United States at the time.
So you're the record holder of being the longest law intern for 3 years.
I think so.
Okay.
A distinction that I am somehow not that proud of, Your Honor.
There is a reason for that.
Thank you.
In your decision that you submitted to us, Justice, the draft decision, you remember that one? Well, it is not something about that one, but you mentioned there the concept of void for vagueness. Remember that one,
Oh,
that
okay.
phrase. So what is your understanding of void for vagueness?
laws that are passed should always have reasonable basis. There has to be standards within which the public would be able to understand how the law is to be applied. Void for vagueness is when there are certain provisions in the law that would somehow enable various interpretations. Void for vagueness sometimes may be used by the Supreme Court to strike down a law.
How about unjust vexation? Can you consider that, no, as being void for being vague?
Being vague.
Well, diba, if we look at
Right.
Article 287
27.
of the
Revised
Revised Penal
Penal
Code,
Code.
diba? Other coercions or unjust vexation. And yet, we interpret unjust vexation to be what?
Anything that annoys
Which it should be interpreted in relation to other,
other.
diba? Other
Opo,
forms
opo.
of coercion.
Opo.
And annoying someone is not form of coercion. If you are going to look at statutory construction. Huh?
That is right. No? That's an interesting point, Your Honor.
So do you think
But-
this unjust vexation is void for being vague?
I believe that it is not vague in the sense that it had already been constantly been referred to and applied already by the Supreme Court. And effectively, there are already guidelines that may somehow put meaning into fixation or unjust fixation.
Is that judicial legislation on the part of the Supreme Court when they could have interpreted it in relation to other forms of coercion?
Coercion. I think that that's an
You're
interesting point.
You're just for just an opinion, Justice.
Yeah, I believe that unjust fixation it has already been there for decades, Your Honor. So
Precisely, it's not a form of judicial legislation.
in a way, but I am not certain if in the process of interpreting unjust fixation, the Supreme Court in its decisions went back to see the intent of the legislature in coming up with unjust fixation as a felony. If they did, then perhaps, or I'd like to think that there is no judicial legislation in that case, Your Honor.
So you placed one of your brads, no? COA Chairman Liel Cordoba, as one of your character references. No? So
That is
can you explain to us, no, the concept of net disallowed amount in COA cases? Are you familiar with that? Net disallowed amount.
I am familiar with disallowances, Your Honor. Disallowances are those that the expenditures are disallowed by the Commission on Appointment. But insofar as
The
net
net disallowed.
disallowance, I am sorry, Your Honor.
Yeah. Actually,
Given
Chair-
enough time to do the
Part-
necessary research
You can
work, I
ask
should be able-
Chairman Liel.
Opo, opo. Thank you, Your Honor.
By the way, Justice, out of curiosity, you're a CPA lawyer, but you mentioned you did not practice technically. You're
That
being
is
a
right.
certified public accountant.
That is right, Your
So do you
Honor.
have, does a CPA like you have to renew the
Yes.
license every
Yes.
now and then?
Yes.
So how
I
often
have,
do you,
I have renewed my license. Oh, but I think
every 3 years like MC, you have to
there's a
attend?
period, but I think for a few years since I'm with the court already,
Mm.
I may have forgotten to check on that. That is something that I have to look into
Baka
immediately after this
ma-
interview, Your
usurpation
Honor.
ka, Justice.
Thank you
Okay,
for the
that-
reminder po, Your
The
Honor.
reason I'm asking this, for instance, the corporation, about taxation, the corporation overpays taxes for a given taxable year. So what are the two options given by our law fact jurisprudence no, for this corporation?
Options with respect to what po, Your Honor?
Because it overpaid. It's,
Overpayment.
overpayment of taxes for a given taxable year.
The options available under the tax code is for it to be claimed as a refund or seeking the issuance of a tax credit certificate, or to apply it as a credit for the next taxable year.
So, question is, are you familiar with this irrevocability doctrine in taxation?
Yes, Your Honor. Particularly with respect to the situation that you just adverted to. Once the option of a credit had already been claimed and exercised by the taxpayer, he can no longer choose to seek a refund or the issuance of a TCC. But the other way around is not true. So much so that if the corporation would opt to file a claim for refund at the first instance, the corporation in the future would still have that option to apply it as a tax credit. But once that option of utilizing it as a tax credit has already been exercised, then the irrevocability rule kicks in.
Would this irrevocability rule apply no, to a corporation who has ceased operation by reason of bankruptcy? Actually, it's in relation to the recent pronouncement no, by the Supreme Court. Kasi it's unfair. No? How can it choose the other one? It is no longer operating no, for the next, for the succeeding year.
I believe that the ruling of the Supreme Court is to the effect that the irrevocability rule should still find application because that is what the law says. So despite the fact that the corporation had already ceased operating, it effectively had already waived that portion which it can no longer use as by way of a credit for succeeding years.
So you also placed Commissioner Meneses no, as your reference,
Apo.
character reference. So this is with respect to labor. No? Does a probationary employee enjoy security of tenure?
Yes, a probationary employee enjoys security of tenure
And
to the
therefore,
extent
he can
of,
be
to the extent,
illegally dismissed, di ba?
I'm sorry.
And therefore, he can be illegally dismissed. Di ba? Pwede
Opo, opo.
ma-dismiss. no?
That is
So
right, Your
there can
Honor.
be. So the question is, if there is illegal dismissal and reinstated, the Supreme Court varies also in interpreting this provision. If reinstated, this probationary employee, and of course, given the back wages, how much back wages are you going to award? Would it be limited to the
Probationary
unserved probation period, or will be up until the decision becomes final?
If it is clear from the facts of the case and it has been duly established that the employee is a probationary employee or worker, in the sense that the necessary guidelines or criteria to be used in evaluating the employee for him to become a regular member were duly and properly explained to him, then whatever back wages that may be he or she may be entitled to should be limited to the 6-month period. And once he is reinstated, there is that option on the part of the employer to evaluate him when the time comes prior to the end of the period to see if he can be regularized. Again, Your Honor, I put emphasis on the premise that his status as a probationary employee was duly established.
Okay. With respect, next question would be in relation to the recent pronouncement from the courts. No, you're familiar with the petition for confirmation of imperfect titling properties. You have handled several cases about the issuance of original OCT, original certificate of title. So one of this actually happened. No, the petition was dismissed for the confirmation of imperfect title. Why? Because the petitioner, because the law says, Section 14, PD 29 says, those persons or their predecessors' interest who have been in open, continuous, exclusive, notorious possession and occupation of the land of public domain under the bona fide claim of ownership since June 12, 1945, 46, no? Because the applicant failed to present evidence, no, that would suit these elements provided for by Section 14. So the petition was dismissed. On appeal, no, the new law took an effect. You know the new law. It simplifies. Instead of this, since June 1945, it now says for 20 years. So question is, should this law be given retroactive effect such that this petition for the confirmation of imperfect title be granted?
I believe that there had been several occasions already in which the Supreme Court, despite dismissing the petition because of the lack of basis and because of the superseding event, which is the passage of the law, still remanded the case to the lower court for the reception of evidence to establish the fact that the requirement of being in possession for 20 years prior to the time of application can be established. This is to provide the applicant with that opportunity so that they can take advantage of the law instead of dismissing the case outright and giving that applicant another round of opportunity to go through the process of filing another case, which would be circuitous.
On the basis of the new law, no?
Opo, Your Honor.
So, next question. So what is the relation of the doctrine of transcendental importance to our procedural laws?
The doctrine of transcendental importance kicks in or comes into play when the Supreme Court decides to take up a case despite it being not involving a case that is ripe for normally
So
adjudication.
in other words, it relaxes
It relaxes.
the procedural
Apo.
law. So what is your parameter? No, how would you determine that a case is of transcendental importance? No, that would impel you to relax the procedural law. Now you are the Supreme Court Justice.
It must be. My position, Your Honor, is that it should be something that should serve as a guidance to the public, the bench and bar. Because the issue involves something which is paramount and important, so much so that the public should be guided because of the potential harm or impact it may have on fundamental rights. Also, as I had mentioned earlier, if it involves something that is capable of repetition. Again, the purpose being so that the public, the bench and the bar, would be properly guided. So much so that future similar cases may be avoided.
So another question from the academe. So what is your understanding of transformative leadership?
Transformative leadership. I think it is the ability to be able to adapt to the changes or to societal needs. Transformation requires taking into consideration what the real world scenario would require. So I think it is imperative for leaders to be hearing what the needs of the public are.
So how would you display transformative leadership, no, given the fact that you will be the most junior associate justice of the Supreme Court? So how can you lead them, no, through this concept of transformative leadership?
I think that it is important to be always taking into account the views of other members of the collegial body And my premise would also be that the other members of the collegial body would have the same viewpoint. So much so that the inputs, the positions from the most senior to the most junior would be accepted and taken into consideration so that in the process of coming up with a decision, each magistrate or each member would have an equal vote and an equal say.
Last question, Justice. You are aware that there are several economic provisions in our Constitution. So how do you intend, no, should you become an Associate Justice of the Supreme Court, how do you intend to interpret these economic provisions? Of course, we have to balance things. There is a constitutional provision regarding the state policies which provides, among others, that natural resources should be effectively controlled by Filipino citizens. On the other hand, no, the truth of the fact is that we need also investors. Diba? So how are you going to balance this, no, through your Supreme Court interpretations?
I think, Your Honor, that it is important for one to always look at the textual provisions of the law first. That is the first guiding principle for me. I always look into the provision of the law first. If the legal provision is clear that an act is prohibited, then I think we have no choice but to apply the law. If it calls for, or if there is an opening that would call for an interpretation of the law, it is only in that instance where we take into consideration external factors. By external factors, I would refer to, perhaps, again, as I have mentioned earlier, real-world scenarios, taking into account societal needs and, in general, the needs of the people, whatever outcome would be for the greater good of the society. That, I think, would serve as a guiding point for me in the process of interpreting the constitutional provision, Your Honor.
Thank you, Justice.
Thank you po.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marifeg. Good morning, Justice.
Good morning po, Justice.
Are you still strong? You're not hungry? Kaya?
Okay pa naman po. Salamat po.
I have several sets of questions here. The first set comes from the Secretary of Justice, and the other sets come from the retired justices whom I represent. I'll just interject some of my questions as we go along.
Apo.
I'll start with the questions of the Secretary of Justice. Question number 1, you completed your LLM or Masters of Laws at the University of Pennsylvania and underwent training at Harvard and Duke. Can you share how international legal exposure has shaped your understanding of judicial review or constitutional interpretation?
During my stint, or when I was with the University of Pennsylvania, my focus was on tax and on intellectual property and corporation law. There was no course that involved the Constitution. However, having said that, when I was there, I was exposed to the system in the US, which is, although somewhat similar to our system, had also other dissimilarities. I observed that the fundamental rights granted under the Constitution particularly those that are referred to as the First Amendment rights under the US, are very sacred to them. And I also noticed that there is always a willingness on the part of the Supreme Court, most especially the liberal side, to interpret this and to establish public policy on this matter. This has enabled me to somehow open my eyes to conflicting views. And I hope to somehow be able to take advantage of this experience if I would have the opportunity to serve in the highest court of the land.
Question number 2, how do you reconcile legal correctness with justice in difficult cases where the law appears clear but leads to harsh or inequitable results?
As I had mentioned earlier, I am of the belief that the first and foremost duty is to apply the law. So that's why we have the principle dura lex sed lex. The law may be harsh, but that is the law. So for as long as it is expressly provided for under the law, I find myself being bound by the legal provision, so much so that I may be left with no other recourse but to apply the law.
Thank you. Given your appellate background, how would you approach the task of laying down doctrine as a member of the Supreme Court rather than merely applying precedent as in the Court of Appeals?
I'm sorry po, Your Honor. Can you repeat the question?
Given your appellate background, how would you approach the task of laying down doctrine as a member of the Supreme Court rather than merely applying precedent as in the Court of Appeals?
I think it is important to give respect to established judicial precedents. So, as I mentioned earlier, that pragmatism should always factor in respect for established judicial precedents. However, if I feel strongly that perhaps due to the changes in the society, a revisit may be called for already, then I think I will be open to the idea of revisiting an established doctrine and consider the possibility of amending, altering, or even perhaps overturning that established doctrine.
Okay. It can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
A lot of our constitutional provisions find history in the U.S. Constitution, most especially the fundamental rights provisions. So while a lot of the Supreme Court decisions in the Philippines have considered U.S. jurisprudence on similar provisions, I think that we should be careful in always taking into account the unique social, cultural, historical perspectives in the country, and also consider the values and wants and needs of the Filipino people instead of blindly following U.S. jurisprudence.
Number 5, with your long years of practice of law and now as an applicant for a Supreme Court Justice position. Can you share us your judicial philosophy?
The judicial philosophy of a judge plays a vital role in the way he analyzes legal issues before him and the way he decides cases. At the core of my judicial philosophy is a strong commitment to the rule of law and the equal administration of justice. It is the solemn duty of every judge to apply the law equally, impartially, without fear or favor, and without prejudice, and taking into account political considerations. Now, having said that, I find the need for a disciplined approach to give priority to the textual provisions of the law. As I had mentioned earlier, being a textualist, I would always find myself starting with the law and the applicable rules. But of course, there is a recognition that the law is not always clear and unambiguous. And more often than not, we would be called upon to make the necessary interpretations of conflicting legal principles or policy considerations. In the process, I repeat that I apply the practical approach and take into account actual scenarios, actual lives, and the needs of the society. But again, this has to be tempered with what I have mentioned earlier as established jurisprudence in order not to undermine the stability of the law. Another policy that resonates in me is the principle of empathy. I always stress to my lawyers in the court that although what we are faced with are merely records and just names, these are not just faceless names. These are actual people with actual lives, and whatever decision we come up with would have a huge impact on these people. So in every case that I decide, I give it equal time so that I would come up with a proper decision that would not only be acceptable to the parties, but also acceptable to the public, and also, of course, to the Supreme Court in the event that it will go up to the Supreme Court with the hope that it will be sustained or my position will be sustained, Your Honor.
Okay, you mentioned you're a believer of the rule of law. What are the four universal principles of the rule of law?
The rule of law requires accountability. All persons that are within a certain jurisdiction are accountable, whether public or private. All laws that are passed must be just and reasonable, and there must be a functioning good government that takes into account the welfare of the people. And lastly, there must be a judicial system that is fair and impartial and easily accessible to the public. Your Honor.
Correct. Do you have a particular justice here or elsewhere whom you consider an idol, and why?
An idol. For the present incumbent justices, elsewhere. Apa. Okay, thank you for the clarification. I think it is important for decisions that come out to be clear, precise, and not overly legalistic or flowery. So I tend to put more admiration to justices who come up with decisions that are simple, fair, easy to understand. Also because this is a way of reaching out to the public so that the public, especially those who are unlettered in the law, would have more idea about the decisions that are handed down by the courts. If I recall correctly, it was former Chief Justice Artemio Panganiban who started out with decisions that are divided into different sections, usually into the antecedents, the lower court ruling, the Court of Appeals ruling, the issues, and the discussion. I find this approach to be more simplistic, especially taking into account the viewpoint of the public at large. And based on what I'm seeing, most of the decisions, if not all of the decisions now, are patterned this way. So I think this is a good way to present decisions. The Senior Associate Justice Marvic Leonen does his in Roman numeral, his divisions in Roman numerals similar to the way Supreme Court decisions in the US are handed out. This is also, to me, a nice approach to be able to come up with the decision that is clearer. That's my answer po, Your Honor. Ano po? Sorry.
Assuming you were appointed to the Supreme Court and given the short or long number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Aside from decision making, I think that a member of the High Court, being a representative of the entire judiciary of the country, must be cognizant of the changes that are taking place, most especially with respect to technology. When I started out practicing law, the first thing that I noticed is the great disparity between those who are moneyed and those who have less in life. Accessibility to courts was a seeming or an obvious problem. Another problem, I think, is the apparent numerous stages of appeal before a case is concluded. In other words, delay. I think that with the SPJI that is being introduced by the Supreme Court and spearheaded by the Honorable Chief Justice, this is a huge step in the right direction. As a member of, if I would be given that huge responsibility and privilege of becoming a member of the High Court, I would continue to review the policies of the court with the end in view of ensuring easy accessibility of the court to the public, as well as ensuring that cases are decided in a timely manner. Because I believe that despite the obviously clear and laudable objectives of the SPJI, there will always be changes, and the court should always keep itself abreast with the changes of the times, Your Honor.
Next question. In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege without the evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence? Oh, this is a question. How do you reconcile the principle of nullum crimen sine lege with the involving nature of crimes in the digital age, such as cybercrimes and artificial intelligence assisted offenses? Should the judiciary have the power to recognize new crimes absent explicit legislative provisions?
It is important for one to recognize, Your Honor, that with respect to criminal law, a crime is a crime only when so defined by the law. If certain acts of individuals, though it may be viewed though viewed as potentially infractious of certain norms of the society, if there is no law that would punish it, then such actions would not constitute a crime. So, in response to your question, Your Honor, I would...
Question of the Secretary of Justice.
I'm sorry po. So I think it is imperative for the court to dismiss the case and perhaps come up with a recommendation to the legislature to perhaps take into consideration the fact that the action of the accused may be potentially injurious to the society as a whole, and for them to consider crafting a law that would possibly penalize similar actions in the future. If I may add, Your Honor, the question of the Honorable Secretary of Justice relates to digital... example.
Such as cybercrimes and
Opo.
artificial intelligence assisted offenses, AI.
AI. Your Honor, because of the advancement of technology, there would inevitably be actions in the future that would not be covered as yet by existing penal laws, but which may nonetheless be deemed as criminal in nature. So I would, again, go back to the basic principle that if there is no law, no law against it, it's not a crime, so that the proper course of action would be to dismiss the action with perhaps the recommendation to the Congress.
Have you heard about the new law in the US about DeepSeek? DeepSeek.
DeepSeek,
Yes.
I'm sorry po, Your
Hindi,
Honor.
okay lang, oo. I just read about it, wala pang details.
I'm not aware
So
of
it's
the
just
case,
new,
I'm sorry.
just the other day.
Apo. Salamat po.
Question number 9. The principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
Your Honor, I came across an article about mandatory minimum sentences, or MMS. I understand that this finds application in Canada or in US. But the counterpart here, or what is akin to MMS here, is the indeterminate sentence law, wherein a minimum sentence is to be imposed by the court by way of a penalty for the accused. If it is something that is already provided by the law, again, we go back to the basic premise that the court is to apply the law. If the court would feel that it is cruel, then perhaps the court can recommend to the legislature to consider its position and revisiting the pertinent provisions in the hope of coming up with a provision, a mandatory provision that would take into account the court's views, Your Honor.
Okay, question number 10. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? How should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
As a jurist, as a magistrate, we go back to our basic training in law and understand that the presumption of innocence is a constitutional right that must be respected. And I understand, or I feel, that as a jurist, it is already deeply ingrained in us to be silenced by public opinion and to just always concentrate on the case before us, consider the facts before us, and to apply the law as it is stated. So despite all the noises from the media and from the public, which obviously is something that cannot be avoided, it is still imperative for the judge to stay true to the law and apply the applicable provision, most especially the presumption of innocence, which would come into play in all cases.
Earlier, I was referring, I made a mistake. I said deep seek. It is deep fakes.
A deep fake.
Deep fakes, just the other day.
Apa.
Okay, question number 11. What unique perspective do you believe you offer that a current member of the Supreme Court may not possess?
Ano po? Can you say it again, please? My apologies.
What unique perspective
Perspective?
do you believe you offer that the current member of the Supreme Court may not possess? Yun ang wording.
The perspective of the current learned justices, I'm sure, would have already considered this particular, perhaps, view that I may want to share. Am I allowed to share an experience before? When I was in,
Question is really very general.
Opo, when I was in private
It's
practice,
not referring to one particular
Apo.
justice.
When I was in private practice, Your Honor, I recall of an instance in which we were called upon to coordinate with U.S. lawyers for purposes of instituting a case. The process of gathering evidence at the onset was very important for the U.S. counterpart, so much so that when the time came for the complaint to be filed, we had all the evidence already in place. That was a foremost requirement. Another thing that I found peculiar, which really struck me, was the use of the modes of discovery during the process of the case, which eventually led to a shorter period of time before the decision came out. I think that the provisions on the modes of discovery somehow in the Philippines are actually underutilized, and they may be taken advantage of to be able to fast-track the resolution of cases.
You were referring to trial courts, not
Apo.
not the appellate courts or
Apo.
discovery na eh.
Opo. That is right, Your Honor.
The last question of the Secretary of Justice. The question of Justice Abad, I think you covered this already. You said you apply first the literal meaning of the law. You are an originalist.
Apo.
Correct. Oh. Will he was a professor in Ateneo. Justice Brion, is there a difference between strict scrutiny and strict construction? Explain your answer.
Strict scrutiny is a test that is utilized in the process of resolving constitutional issues involving First Amendment rights, or rather the rights of free speech and free expression. On the other hand, sorry, Your Honor, what's the strict interpretation?
Strict construction.
Strict construction refers to the manner in which particular provision of the law is to be interpreted.
That's correct. Estrada versus Sandigan Bayan. Explain fully the concept of protected speech and unprotected speech.
The Constitution guarantees freedom of expression and freedom of speech. So as a rule, all forms of speech, generally speaking, are protected. This would include freedom to give your opinion, freedom to gather and consider information, freedom to express contrary views. It is only when speech oversteps the boundaries of something that is contrary now to the public welfare, public morals, and public policy, where it can now be considered as unprotected. This would include calls to overthrow the government, immoral acts, obscene acts, libel. Your Honor.
In connection with that, what are the essential elements of the freedom of expression?
The essential elements of freedom of expression are, number one, freedom from restraint with respect to those that have not yet been uttered or published, and freedom from punishment for those that had already been published or uttered.
Okay, that is correct, but can you modify restraint and modify punishment?
Modify
Yes.
restraint. Prior restraint.
It is freedom from previous restraint. Prior restraint is correct. And
Yes.
freedom from subsequent punishment.
Freedom from subsequent punishment. Apa. Thank you, Your Honor.
We now go to Justice Tiham. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer.
There are certain procedural matters which delve into fundamental constitutional rights, such as the right to be presumed innocent, the right to counsel, the right to confront witnesses, right to a fair and impartial hearing. If the procedural infirmity in the case would border or touch on the fundamental rights of the accused already, then I think there is reason to call for the acquittal of the accused, Your Honor.
Thank you. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation?
Your Honor, the judiciary being the most I'm sorry, Your Honor.
Dangerous branch of government.
Most dangerous branch of the government. It has always been said that the executive branch wields the power of the sword because it implements the law and it is in a position to call on the military for action, while the legislature has been referred to as the one that possesses the power of the purse. The judiciary, on the other hand, is always referred to as the one that has the power of the pen because it interprets the law. There are checks and balances in place to ensure that these three branches of government remain equal. So in that sense, Your Honor, I think that the judiciary cannot be considered, my position, Your Honor, and that the judiciary is not to be considered as the most dangerous branch of the government.
Thank you. I think you can easily answer this. You took up Masters of Laws in University of Pennsylvania, and you also took some courses in Harvard and Duke. In the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th?
The Solicitor General in the U.S. is widely referred to as the 10th Justice in the Supreme Court, Your Honor.
That's correct.
If I may share an experience, Your Honor, when I was, if I may po,
Sige, sige.
when I was studying in the U.S., I had the distinct opportunity and privilege of joining a field trip to the U.S. Supreme Court and to listen to an oral argument before the U.S. Supreme Court. The Solicitor General was the one arguing for the government. And he was referred to as the 10th Justice, and I was informed that he also has an office in the U.S. Supreme Court.
Next question. What is the doctrine of the rule of 4 adopted again in the U.S. Supreme Court?
The rule of 4. The rule of 4 is a rule in which 4 members of the Supreme Court may be allowed to consider accepting or taking cognizance of a case. 4 not being a majority is to enable the minority to somehow override initially the views of the majority.
Can you explain further why initially? You use the word initially.
Because if a majority, 5 out of 9 being a majority, would decide not to take up a case, and the remaining 4 would be of the view that there is reason for the High Court to take up the case, then normally the 4 would already be outvoted. But because of the rule of 4, the court would consider taking the case to consider the view of the minority.
What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution?
Birthright citizenship is when a person acquires the citizenship of the place in which he was born. Birthright citizenship is not available in the Philippines because Article 4 of the Constitution is very clear that Filipino citizenship is premised on the Filipino citizenship of the father or the mother. We adopt the principle of jus sanguinis as against the principle in the US, which is one of the principles in the US, which is jus soli, in which those who are born in the US has birthright citizenship in the sense that they become US citizens already.
Thank you. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
Vehemently. Ano? By, by way of training, whether as a lawyer or as a judge, we have always been taught to accept what the Supreme Court says and to always follow the decisions handed down by the High Court. But having said that, Your Honor, I guess it is natural to sometimes somehow feel that a contrary view may perhaps be rightly taken into consideration. A matter that I feel respectfully may somehow be considered for being revisited is the mandatory imposition of damages, Your Honor. Mandatory imposition of damages in crimes, because my feeling is that it somehow takes away the discretion of the trial court, and it does away with the different factors that may somehow justify a higher damage or a lower damage.
Okay, thank you for that view. Have you read the case of Valenzuela, written by Justice Kagiwa?
Valenzuela.
Yes. Anyway, even
Valenzuela is, if
there it was stated that in criminal law, intent to commit a crime is different from intent to perpetrate the act. What is your understanding of that, and how was it developed?
intent to commit a crime, Your Honor, has to do with crimes that are classified as mala in se, or those that are inherently wrong. On the other hand, intent to perpetrate a crime has to do with crimes that are classified as mala prohibita. Because aside from establishing the fact of having committed an act, it must additionally be shown that there is voluntariness in the commission of the act. There must be that intent to commit the act. Although there is no criminal intent in the sense that there is an intention to commit a crime, there must be an intent to commit that particular act which is constitutive of the crime classified as mala prohibita, Your Honor.
What is your understanding of intent is immaterial in mala prohibita, in crimes described as mala prohibita?
The intent to commit a crime being, I'm sorry, sir, did you say inconsequential?
Yes.
Inconsequential?
Yes, it's immaterial.
Ah,
It's
immaterial, sorry. Yes.
Inconsequential. You need not prove intent. That was what we studied before.
Yes.
Yes.
Yes, it is immaterial in mala prohibita because intent to commit a particular crime is not an element, Your Honor. What Valenzuela clarifies or puts in as a doctrine is that there must be an intent to commit a particular act. That is what distinguishes it from intent to commit a crime, Your Honor.
Thank you very much, Justice. That will
Thank
be
you.
all. Your excuse.
Thank you po.
Thank you, Justice Mendoza. And thank you, Justice Walter Oong.
Thank you.
Good luck po.
Thank you. Thank you, Your Honors.
We will have a lunch break and we will resume at 1:30. 1:30 po. Good afternoon, Your Honors. We will now resume the public panel interview of the candidates for the position of Associate Justice of the Supreme Court, Vice Honorable Mario V. Lopez. Present in this afternoon's public panel interview are the following members of the Judicial and Bar Council. We have the Honorable Justice Jose Catral Mendoza, regular member representing the retired justices of the Supreme Court, and JBC Executive Committee Chairperson. Honorable Attorney Nesauro H. Firme, regular member representing the Academe, and Honorable Justice Erlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. Your Honors, the candidates to be interviewed this afternoon are Honorable Ambassador Manuel Antonio J. TEEHANKEE and Honorable Court Administrator Raul B. Villanueva. May we request the candidates to please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Honorable Ambassador TEEHANKEE to please take your seat in the middle, and the Honorable Court Administrator Villanueva to please proceed first to the holding area. Thank you. Good afternoon, Ambassador TEEHANKEE. You may press. Your Honors, the first candidate to be interviewed this afternoon is the Honorable Ambassador Manuel Antonio J. TEEHANKEE. The first to interview Ambassador TEEHANKEE is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, Ambassador TEEHANKEE.
Good afternoon, Your Honors.
I have two sets of questions. One set belongs to the Secretary of Justice, who unfortunately could not attend, but his lawyers and representatives are here to listen to your answers. And then I have my own set of questions. So I'll start first with the Secretary of Justice's questions. You've spent most of your public service career in international diplomacy and economic policy. What specific competencies from that field do you believe will translate into sound constitutional and jurisprudential reasoning as a Supreme Court Justice?
Thank you, Your Honors, for this question. Spending time at the WTO, whose objective is, in its preambular treaty, for the optimal use of the world's resources towards higher standards of living, towards sustainable development and prosperity for all nations. This coincides very well, as well with the declaration of policies of our Constitution for sustainable development and greater prosperity for our country. My area indeed has been in international economic diplomacy. And as a collegial body, the Supreme Court is mandated to consult in all its decisions. The benefits of collegial body is this element of consultation and openness to new ideas. My contribution is my experience during my years in the international economic field, my involvement in the WTO cases that the Philippines were involved in. During my stint in the WTO, I happened to also get involved with 3 cases that involved the Philippines. One was the distilled spirits case, wherein the Philippines was called upon to bring its measures and laws into conformity. And in cooperation with Congress and the executive branch, the Philippines did comply with bringing our sin taxes into conformity with the national treatment and most favored nation clauses of our WTO treaty. So this is but an example of providing some economic perspective for the benefit of the Philippine people. Thank you.
If appointed, how would you approach cases involving international treaties that have not been implemented by legislation but are binding under international law? Should they be directly enforceable in the Philippines?
This is, of course, under Article 2, where the Philippine Constitution itself, and if I may quote, that the Philippines renounces war as an instrument of national policy and adopts the generally accepted principles of international law as part of the law of the land. This is one of the most progressive, as noted by international law commentators, provisions of our Constitution. There is, of course, debate whether certain portions of implementation require national legislation. And here, as a Supreme Court judge, I have to be open to both sides of the arguments on a case-by-case basis. Depending on the nature of the rights and substantive issues involved, certain matters may require legislative guidance, but certain matters may be of such a nature as to have formed part of the international law, customary international law for decades, and is part of the fabric of our constitutional mandate. Thank you, Your Honor.
Number 3, you have handled international negotiations on behalf of the Philippines at the WTO. Describe a situation where you had to make a critical legal or policy decision under pressure, and how would that experience inform your deliberation style as a justice?
An example of this would be the negotiations we have for our dispute with Thailand, and we had to engage in negotiations for their bringing their own measures against our exports into conformity. It was an important issue because we had to weigh the benefits of outright retaliation and countermeasures, which would lead to escalation, as we are seeing in the turbulent trade situation we have now, or to engage in further dialogue with our ASEAN partner and seek ways of trust building and confidence building measures to continue the trade and merchandise exports of our industry. In this situation, there was much debate and internal discussions, and as a negotiator, I would have to be guided by my superiors and capital. So in the context of the Supreme Court, being deliberative, again, I must remain open to both sides of the issue, remain impartial, listen openly and empathetically to both sides, and see where the law can be applied to the particular situation. But in the end, my most important lesson is that calm dialogue, careful listening is very important in order to reach a viable compromise. Thank you.
What unique perspective do you believe you can offer that current members of the Supreme Court may not possess?
Your Honor, that is a very difficult question since the honorable members of the High Tribunal, I have to acknowledge, are much more experienced, and sitting in the library below, I see the tremendous challenge and work ahead for a Supreme Court justice. It is a bit intimidating given the long experience that many of my colleague applicants have. However, having served in the Department of Justice, my first foray into public service was in 2001 as Department of Justice Undersecretary. And this provided me already the rare opportunity of representing the Philippines in 3 major international arbitration cases, where I am happy to say we championed Philippine interests in these international cases. Again, as when I landed in the WTO, I was given again three important cases, one on distilled spirits, one on sin taxes, and one on the exports of cigarettes, and one on our semiconductor exports. So indeed, these perspectives of fair play, economic fair play, and fair trade is probably in the areas of economic and international arbitration where I can best contribute a perspective from the international economic arena. The Philippines, if I may say so, during my long tenure as a diplomat ambassador, is very much well respected, and the economic performance is very well recognized. And indeed, there is so much potential for our economic development. And this is probably where I feel that I can champion and have a vision and contribute to the court in the field of economic rights and commercial and economic business, which is contained in our Constitution, wherein it recognizes the important role of investments and the private sector partnership. Thank you, Your Honors.
It can be said that our Constitution shares some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions?
Your Honor, if I may clarify then, is it the power of judicial review in the U.S. Constitution that you are adverting to?
I'll repeat the question because it's not my question, that's why I cannot clarify. Can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our constitutions? You may answer the way you understood it.
For me, under the declaration of our Constitution on the state shall develop a self-reliant and independent national economy effectively controlled by Filipinos. Having my experience in the international economic field, where there is various interests, including the U.S. Constitution for open markets, and sometimes we call excessive capitalism, I believe I will protect in our Constitution the importance of preserving the economy for our national development and national paramount interest. So indeed, as mentioned by many presidents and instructed to me in all my negotiations, we must put the Filipino first and the Filipino people's welfare first. Thank you, Madam.
With your long years of practice of law and now as an applicant for a Supreme Court Justice position, can you share your judicial philosophy?
My judicial philosophy involves upholding the Bill of Rights. A country can only be proud of itself if it lives in a society that is just and fair and provides equal opportunity to all. Since my college days as an economics major before entering the law school, and following with the inspiration of my late father in the field of civil liberties and human rights, I have found it particularly important and essential that justice for the country, justice for all, involves both civil liberties and economic rights. This has touched me quite strongly. If we do not eliminate poverty and attempt to achieve the Sustainable Development Goals, how can we be proud of our country? SDG 16 provides for the development of strong and effective governance institutions through the rule of law and access to justice for all. Justice for all, for me, includes economic justice and economic rights. Thank you, Your Honor.
Do you have a particular justice here or elsewhere whom you consider an idol, and why?
Indeed, that is hard to say, although I often recall Justice Oliver Wendell Holmes that the life of the law has been experienced. And indeed, the life of the law is one that requires judges to age like wine, gradually and through the years. Having had my experience as a young lawyer, where of course I was quite energetic as a private practitioner, and then now having been 20 years in government service, one's eyes are opened to the fact that one has to be patient and listening and learning from your colleagues and fellow civil servants in government. Because the only way we can bring our country forward is through solidarity and collaboration. Of course, I also remember my father's own comments to me. Sometimes common sense is one of the rarest senses available, and one must keep that in mind. As a judge, as a lofty judge, one must not lose touch with the common people and common sense. Thank you, Your Honor.
Assuming you were appointed to the Supreme Court, and given the number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision-making?
Aside from decision-making, and I understand it is a challenge given the many years that justices evolve their writing style, my immediate task, apart from the decision writing and building a body of decisions, is perhaps to cooperate and collaborate with the Chief Justice's own mission at present, is bringing the Supreme Court closer to the people. And the adage I have in mind, even when I was in the Department of Justice, is how do you bring justice closer to the people when they feel justice is delivered? So, as the saying goes, justice delayed is justice denied. And so, I appreciate all the efforts towards increased efficiency in the delivery of justice. I appreciate very much the constitutional mandate for 3, 12, and 24 months delivery of decisions from submission. And I appreciate very much the digital revolution and the use of digital tools and now AI to increase the efficiency of delivery and hopefully have some aging mechanism for cases. So this would mean the most to me if I could contribute in this aspect. Thank you.
In the context of criminal law, how do you reconcile the principle of nullum crime sine lege, no crime without law, with the evolving nature of crimes in the digital age, such as cybercrimes and artificial intelligence-assisted offenses? Should the judiciary have the power to recognize new crimes absent explicit legislative provisions?
Indeed, this is a evolving area of the law that requires creativity. At the same time, one of the important projects among lawyers, practitioners, and judges is the practice of codification studies or codification systems. The Philippines is a mixed system of codal provisions as well as developing case law. However, if one looks to the acts itself, and given the creativity of our legal profession, I believe in the adversarial system, the prosecution should be able to fashion a reasonable enough statement of the facts as to amount to a violation of one of the many, many laws we have already on cybercrime and invasion of privacy, as well as in the most important right to privacy provisions of our Bill of Rights. The Supreme Court was at the forefront with the writs of amparo and writ of kalikasan, including the landmark case of Oposa versus Factoran, which evolved a doctrine of intergenerational responsibility. Noting, though, that there was a dissent from Justice Feliciano. However, indeed, in a fast-changing world, the Constitution that we have is recognized worldwide, globally, among international law experts as among the most progressive and alive constitutions. So just while I may advert to the US Constitution as being a live document and continually evolving, our Constitution, with its Declaration of Policies and Bill of Rights, I feel is sufficiently substantively alive to progressively be guided by the Supreme Court in the development of laws and crimes.
The principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences, which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
Your Honor, that is indeed a difficult question, since we are duty-bound to uphold the Constitution as well as the various laws of the land as promulgated by Congress. However, the power of judicial review and Article 8 of our Constitution is the paramount organic act to guide Supreme Court justices. There is, of course, the question of the due process and Bill of Rights. The issue of proportionality must then be examined in the light of the other due process requirements, and if there is an abuse of power or of legislation, such as to amount to a grave injustice. But then again, it would be quite delicate and something that, as a sitting judge in a collegial body, I would have to be open to listen to the varying views, propound a view, but remain open to be persuaded otherwise. Thank you, Your Honor.
Last question. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? How should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
Indeed, this is one of the most common experiences, that one may be presumed innocent until proven guilty under the law, but the public has a right to its own opinion, which is, of course, part of their free ideas and free speech rights. And of course, we have the libel laws to counter those issues where one feels that one's reputation has been tarnished by the actions of another individual. This forays very much into the area of our constitutional mandate that public office is a public trust. And so many decisions have given enough leeway for the media through good faith reporting, provided there is no malice aforethought, to protect this area of constitutional liberty. Because without free speech, free flow of ideas, then the very rights we are attempting to protect could also be put in danger. So a very difficult question indeed. And again, one must exercise the qualities of a judge and act in the most appropriate manner, an independent and impartial manner, while allowing the liberty of free exchange of ideas. Thank you, Your Honor.
So that was the last question of the Secretary of Justice. I will proceed to my own questions. Ambassador TEEHANKEE, may I know what inspired you to apply for the position of Associate Justice of the Supreme Court?
I guess as a practicing government for more than 20 years now, and having practiced also law, it has always been the dream, I believe, of a lawyer to aspire to participate in the development of the rule of law for our country. As a personal aspiration, I have sought to serve as a public officer. And as I approach my senior years, I guess, it's not the first time I have applied for the Supreme Court.
How many years time?
I think this is the third. I think I applied when I was in 2019 and earlier when I was. So it is not the first time, but I feel it is my last opportunity. So I'm inspired, of course, by my late father, who served his country for many years. And I have served my country now for 20 years, starting with the Department of Justice, the Department of Foreign Affairs, and also as ambassador. So it's my vision for a prosperous Philippines that I have seen recognized in the international field. And if I can contribute to the goal of the Philippines to be a developed country and provide prosperity to all its citizens by 2040, by contributing in some small fashion to the rule of law towards sustainable development, I feel it will also complete my public service.
You first applied in 2019, am I correct?
I think
What was your position then?
in 2019, I was in my current position.
Already, not
Yes.
during the time when you were with the OJ.
No.
You at that time, did you entertain any plan to join the judiciary?
In the DOJ, that was my first few years of service, so I did not.
Not yet. All right. Can you describe a challenging ethical dilemma you faced in your career and how you resolved it?
I guess one that has been raised in my Commission on Appointments hearing in 2018 and actually raised also in the disclosure, is during the first few months of my arrival in Geneva, I did come to the Philippines in need of a kasambahay. So I did hire under the POE guidelines then that the minimum wage was around $200 a month. And so having entered into the agreement with the kasambahay here at 300, on arrival in Geneva, I was just a few months in Geneva then, I guess after 4 or 5 months, I received a legal notice from the lawyer of the kasambahay that the Swiss wage was over 1,200 or 1,500. So my lawyer immediately advised me to pay the balance, which I did immediately. So the ethical dilemma I faced was later on, after my stint as ambassador, I did receive further notice that they were continuing to make a claim on me. So I was then subject of a penal order and fine in 2013, which I paid, which says there is either 400 fine or 12 days service. So I acknowledge this mistake. And as I said to the Commission on Appointments, the DFA and us have developed many guidelines with the POA since then. In 2006, they increased the minimum kasambahay wage to 400. And then 2015, guidelines were set to avoid further misunderstanding. And in 2021, all our guidelines in the DFA make it very clear that the minimum wage is the POEA guideline or the host or destination country, which is Switzerland. So I have always faced this dilemma whether I have done enough to make up for my mistake, because ignorance of the law excuses no one. And so I did make one mistake for which I suffered the fine, and I still have this ethical dilemma today whether this can serve as an obstacle to my serving as a justice.
May I clarify, you mentioned about a penal order. Was that served?
Yes,
Because you said penal order and fine.
Fine, yes.
So you did pay the fine. What was the penal order all about? If you remember,
yes, I have submitted it.
did you have to serve sentence?
No, it's an or.
It's or, it's not and.
Yes,
Okay.
yes.
That's in your PDS, it is reflected that you handled 6 international trade issues. Can you briefly discuss what were these issues about?
Well, one of them relates to the mentioned syntaxes, and one of them involves also the semiconductor trade, wherein we acted as a petitioner-intervenor against the European Union imposition of tariffs on flat panel screens. While under the ITA treaty, the tariffs should have been 0. So in this issue, we dealt with and won in the case brought by the United States versus the EU and Japan as well. So in that case, we were able to require the European Union to bring their tariffs into conformity with the 0 level.
Also reflected in your PDS is that you have 15 years of experience in civil litigation. Can you mention what fields of law did you handle?
In terms of my practice of law, I did civil and commercial litigation, as well as arbitration cases, wherein I also sat as one of a collegial body of 3 arbitrators involving insurance claims. So this was during my private practice.
Did you ever appear in court? Did you did you handle trial?
Well, yes. As Government Corporate Counsel, I appeared before this chamber and also appeared before international tribunals.
What about the lower courts?
In the lower courts, I have appeared during my first few years of service as a lawyer, but that was in the 1980s.
How about your experience as a research fellow for 9 months in the Energy Research Institute, as well as in the Center for Trade and Economic Integration for 4 years? Can you describe your experience as a research fellow?
Yes, during 2011, when I ended my first stint as ambassador to the WTO, I then fulfilled my dream of...
You may drink water.
Thank you. Thank you for this question. In 2011, as I completed my first mandate as representative to the WTO, I was fortunate enough to pursue my dream of a PhD in international law. As part of the preliminary research for my PhD, I was awarded a fellowship in New Delhi, India, by the Energy Research Institute, under then Nobel Prize winner Dr. Pachauri, who was co-awardee with Vice President Gore. I had been chairing in the last years of my ambassadorship the Committee on Trade and Environment, wherein we were spearheading the negotiations on trade and environment goods. So the issue of sustainability and energy efficiency was high on the international agenda. And so my fellowship in the Energy Research Institute in India helped pave the way for my further development of my thesis in the Center for Trade and Economic Integration, where I did my PhD at the Graduate Institute in Geneva. This led to my thesis and publication on the Committee on Trade and Environment and Trade Governance, International Trade and Environment Governance.
To your mind, what impact, if any, does this experience carry in relation to your current application for the Supreme Court?
Again, in the economic field, even when I was in the Department of Justice, one of the important laws was the efforts of the legislature to bring down energy costs. One of the most important factors for economic prosperity and efficiency is bringing down energy costs and the importance of sustainable energy sources and infrastructure. Again, the Philippines is faced with many challenges, and infrastructure and the development of sustainable sources of energy and lessening the cost of electricity and energy is among the prime movers of an economic development policy. So it may not directly be legal, but a lot of the laws of our legislature are dealing with how to enhance public-private partnerships, develop infrastructure, and best practices in the global field for environmental governance. Thank you.
Are you familiar with the Data Privacy Act of 2012?
Not very much, but I'm familiar with the
Can you
the
name
rules
some
on
ways?
habeas
Data.
Yes.
Okay, what crimes are covered? How is it committed? Violation of the Data Privacy Act. If you can name some manners of commission. of crimes?
Releasing without authority photos or videos of a private party, recording without authority, those types of, and then disseminating those types of private matters through electronic means.
What are the instances when the court may still pass upon a main issue although the case is already, or although the cases are moot and academic? So like in the Supreme Court, if you do get appointed, when will you entertain a case where it's pertaining to an issue that is already moot and academic?
When it is in such a manner that the jurisdiction has already vested, this is my understanding, and while certain issues are moot and academic, there is still some area of guidance that the court may provide in the interests of guiding the public and stating the policy, which is of importance in the development of the rule of law and avoidance of a convenient way to avoid a ruling that may have some important policy impact.
Any other grounds?
I apologize, Your Honor.
Grave violation of the Constitution, when the case is capable of repetition yet evading review. Let me ask you about executive privilege. The House Committee on Peace and Order conducts an inquiry in aid of legislation into alleged death squads and vigilante groups of the Philippine National Police in alleged informal alliance with the CPP-NPA. Implicated are high officials of the palace. The House Committee summons the DILG Secretary to appear and testify. However, the Secretary refuses to appear, invoking executive privilege. May the Secretary be compelled to appear and testify? And please explain your answer.
On executive privilege, provided there are matters of national security, the DILG may express his, on behalf of the President, executive privilege. But again, I'm not 100% certain on the qualifiers for executive privilege. But executive privilege is given wide latitude, especially in matters of national security.
But in Senate versus Ermita, the Supreme Court said that the President or the Secretary, by authority of the President in writing, can invoke executive privilege. Other than that, it cannot be invoked. Anyway, that was the ruling in Senate versus Ermita. One last question. What is a valid delegation of legislative power? There are two tests.
Valid delegation of legislative power requires the authority must be of such as to avoid, as to have the discretion for the delegation of legislative powers.
Yes, valid delegation of legislative power. There are two tests to determine whether it is valid or not. What can be delegated? How can it be delegated?
The legislature can delegate its power to an executive body, provided that there is standards by which the agency can act and exercise its delegated power. And this must be contained in the delegation.
Yes, that's correct. But one additional test is the completeness test. So completeness test and sufficient standard test. That's my last question, Ambassador. Good luck to you.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Marife. Good afternoon, Ambassador. So
Good afternoon, Your Honor.
How did you prepare for today's interview?
I tried my best.
You should always try your best, even without a forthcoming interview. So if appointed ambassador, what can the stakeholders expect from you?
Stakeholders can expect hard work. I have been devoted to my work for many years. Can also expect intellectual curiosity, an openness to listen to all sides, independence and impartiality, and they can expect that I will champion development and economic rights.
Yeah, I heard earlier you mentioned about SDGs. No? Unfortunately, you mentioned 16, but they are 17. So if ever you will become an Associate Justice of the Supreme Court, what or how can you, what will you do, no, as a magistrate of this High Court, no, to attain the any or some of the 17 SDGs?
Well, of course, the first task is to really learn from my elder colleagues, the more senior colleagues, on the ways of the collegial body of the court. In terms of the 17 SDGs, the one that has the rule of law is SDG 16, and the importance of strong and effective governance institutions. So being part of the Supreme Court is the third branch of government of building a rule of law and strengthening the different branches of government and the power of government to work harder for the people. Of course, the other SDGs deal with education, elimination of poverty, and yes, zero hunger, zero poverty. These are all part of the economic development of our country. And that is why I think the courts are mandated to cooperate and collaborate and assist government agencies in their functions. While we do have the duty to guard against abuses of power, we also have to safeguard the ability of government to be able to deliver and act effectively. So it is indeed a balancing action for judges and the court, the third branch of government, to give effect to the legislative mandates, assist the executive in the implementation of laws, and build the nation and move forward, while guarding against any abuse or violation of the Constitution.
Yeah. So I heard earlier the answers to some of the questions propounded by the panel members. I'm interested in knowing what would be your stand or how do you want to interpret some economic provisions of our Constitution? Because you are aware no, that, of course, we have to be liberal, no? If our objective is to attain economic growth, No? In fact, in one case decided by the Supreme Court, it is said that in interpreting constitutional provisions, we must not strangulate economic growth. No? Vis-a-vis the right of the people, no? As mentioned in Declaration of Principles, that natural resources have to be effectively controlled by Filipino people. So how do you want to, or how would you interpret constitutional economic provisions?
In economic policy making, great deference is given to our economic planners or the economic planning agencies of government, as well as to the legislative inquiries and reports prior to the passage of legislation. One has to give the benefit of the doubt to those that are more expert. And the job of the judicial department is to act as the guardrail wherein certain excesses could be made or that are in direct violation of the Declaration of Principles or provisions of our Constitution or procedural or substantive due process errors. So, economic policy making is a business of the economic planners and experts. And through best practices and my exposure in the global economic field, I guess that is part of my what I could contribute to the discussion. It is not that there is a right and wrong immediate answer. In listening to the particulars of a case, one has to be open to the presentation by all the parties as to what constitutional issues may have been transgressed or violated. But in general, great deference should be given to our economic experts if consistent with international best practices.
The Constitution mentions two modes where the state can exploit, develop, and utilize our natural resources. And that is number one, by directly undertaking the exploitation, development, and utilization. And the other one is the state can enter into agreement. Would you know what are these agreements the state can enter into as provided for in our Constitution?
Yes, those are the concession agreements or exploitation of natural resources concession agreements.
It made mention of four. First is, you forgot,
Yes.
co-production,
Co-production
action,
sharing agreements,
production
joint
sharing
venture,
agreement,
production
co-production, JV, and the other one is FTAA. Are you familiar with the FTAA? Financial and Technical
Technical and
Assistance
assistance
Agreement.
Yes.
Are you familiar with that?
Yes, in my DOJ days, especially with EPIRA, and working with the Department of Finance and Department of Energies, and as well as our notifications to the WTO, indeed, these are what we have advised international investors, that while we have a nationalization policy, through the effective use of these service agreements and concession agreements, there is guaranteed to the foreign investor cost recovery plus reasonable profit. So in these situations, their stake and investment is protected. And this is one of the key elements that we always promote and advise foreign investors. This is this key provision of our Constitution.
In fact, in that FTAA, even 100% foreign-owned,
Yes.
can engage in the exploitation, development, and utilization. But in the case of Labugal-Bilaan case, if you remember that one, the Supreme Court made mention of 3 constitutional safeguards, which means to say FTAA is permissible so long as it would meet these 3 constitutional safeguards. Would you know them?
Not on the top of my head, but they relate to the preservation of the national share and interest and the protection of are patrimony, that the resource themselves are owned by the national government and not being sold, because they relate only to the provision of technical assistance and know-how.
Supreme Court made mention of three. Number one, the agreement must be pursuant to a general law, which is the mining law. Number two, it is only the president. Interestingly, only the president can enter into this FTA.
Yes, only
and
the
number three, the president must report within 30 days the agreement to the Congress. So whether the Congress would accept it or not, the Constitution did not provide for any, right? Because to report,
It's merely a reporting requirement.
So how do you keep yourself abreast, Ambassador, with legal developments and pronouncements?
Well, I have to confess, the first one is the e-library and the latest reports on the web, and of course the latest articles and decisions.
Well, this is the situation. It was a recent decision, 2023. You're familiar with VAUSI, Ambassador, Violence Against Women and Children. Yeah. So there, in one case, particularly involving psychological violence, economic abuse, the Supreme Court said the dismissal of the criminal aspect does not carry with it the dismissal of the civil aspect. So meaning to say, the RTC in dismissing the criminal aspect must still make a pronouncement as to the civil aspect, the support. Meanwhile, in another case, estafa, if the case has been, the criminal aspect has been dismissed by reason of or after a demurrer to evidence has been filed, that the Supreme Court said the criminal aspect must likewise be dismissed.
You mean the civil aspect?
Civil aspect.
Must likewise be
in the
dismissed.
case of 2021, spouses Oong, the Supreme Court says the remedy is to refile a new one. Can you explain why is there a difference between the two?
Well, in the estafa situation, that's governed by the revised penal code. While the other one, so once the criminal case, if the criminal case proceeds, the civil aspect can be awarded. But if the criminal case is dismissed, there is no original action to hold. While in the violence against women and children, there is a law that provides for the joint jurisdiction of the court for both the civil and the criminal aspect.
So also earlier, Ambassador, I heard you responding to a query about the kasambahay. So you're familiar with the kasambahay law. This actually bothers me, this legal issue. You may want to enlighten me. Our labor code has provisions about house helpers. If you would recall, diba, meron tayong provision about house helper. With the passage of this kasambahay law, it effectively rendered this title or provisions, articles about kasambahay law ineffective. So na-supersede na the provisions on the house helper law with the kasambahay law. Used to be, under the old labor code regarding house helpers, the drivers are included. So meaning to say, if there will be a dispute between the employer and the driver, the driver can file a case with the labor arbiter, anchoring his provisions, anchoring his cause of action on the provisions of the labor code. But this, the driver was removed, expressly removed in this kasambahay law. So technically, there is no law that would govern now the plight of a driver, family driver. So question would be, if there would be sabihin natin illegal dismissal. The services of the driver was removed without any reason, and the driver would want to file a case. Where would he file a case?
That will be, without being a labor expert, except just a wage violator before. That is a simple labor case.
What provision of law would apply?
Would not the labor code?
Well, the provision about the house helper has been removed by this kasambahay law. But this kasambahay law, no, expressly deleted or omitted any concern with respect to driver. So there is no law governing the relationship of the employer and the driver.
But even before the kasambahay law, the labor code provides for grounds for illegal dismissal, separation pay. So it will be interpreted as a reversion to the prior law.
Bumalik. Or would it be wiser to apply the provision? Do you remember that our civil code has provision on labor?
Yes, I mean, either the
Would
civil code or a reversion to the labor code. But
So,
for
which do you think? You are now the Justice TEEHANKEE of the, you are going to interpret.
of course, if I'm the justice, I will have to review all the issuances. But at first blush, I will review first the repeal provisions in the kasambahay law, because it would not have been the intention of the legislature to have a remedy-less situation. And from what I recall, the removal of the driver is related to a different class of employee of high trust and confidence, and usually the wages are higher. And usually it's I can't call it sui generis, but it partakes of the nature of its own relationship of trust and confidence together with a regular employment relationship, and not the same level of superiority or dominance that is present in a different situation of the kasambahay. So I would, of course, review all the pleadings, take into account the constitutional mandate for the protection of labor, and always seek the best result that uplifts and upholds the welfare of the laborer.
Again, in labor law, are you familiar this? No, you studied abroad? You did not?
Yes, I did. I did.
This was borrowed from American jurisprudence, the Weingarten principle. Weingarten principle. You're not familiar with that? It's about representation of the union, labor union. Okay. So you're also teaching environmental law.
My research was trade and environment, the interface of trade and environment law, which deals with sustainability, but still in the field of international trade law.
Yeah. Okay. I would like to ask you about the essence of, you're familiar with the doctrine of transcendental importance. Are you familiar with that one?
Not really, but
Yeah.
it relates to, is it an environmental,
Not necessarily.
yeah, transcendental importance? In the
I'm
sense-
just laying down the basis. Later on, I'll connect it to environmental law. Are you familiar with that? The transcendental importance, the doctrine of transcendental importance.
My understanding of that is that the impact of it transcends the current context and moves beyond the perambula of the current context it has. It can go beyond.
Yeah. So how would you relate that to our procedural laws? If the matter is of transcendental importance, what happens to our observance, compliance, or adherence to procedural laws?
procedural laws must give way.
Yeah. Okay. In one case, no, decided by the Supreme Court, no, the Supreme Court made mention of this one. No, the constitutional right to information and equitable diffusion of natural resources. Are you familiar with that? If there is a constitutional right regarding the right to information and the equitable diffusion of our natural resources. You have not come across with that one. It's about the Chavez versus Peya, about the Amari. Versus Peya. About the... You have not come across with that? Sige, it's okay. No, it's about being lenient or setting aside, no, the legal standing of the petitioner, because the matter involves the constitutional right to information and the right to the equitable diffusion of our natural resources. So in which case, procedural laws, particularly the legal standing of the petitioner, may be set aside. Another case, you're familiar with this one, international law. Is the Philippines a monist or a dualist? Based on your, because these are two schools of thought, no? In relation to domestic laws, no? The international laws and the domestic laws. So do you think the Philippines would be a dualist or would be a monist?
So Father Bernas's theory on this would be that we have an integration clause in Article 2, Section 2, wherein the Philippines adopts the generally accepted principles of international law. However, as mentioned, there are many provisions of international law that are too general, as well as in our declaration of state policies, they are still very general and require further elaboration for them to have effect. So I guess similar to our being mixed common law and civil law influenced jurisdiction, we have aspects of monism and aspects of dualism. But in essence, these are structures that allow us to understand how international law gets integrated through the monist theory, or the dualist theory allows us some understanding how legislation interacts as a necessary implement of international law. They are not fixed structures as to the Philippines to necessarily belong to one, but they help guide us depending on the international law principle involved.
How about the customary international law? What do you mean by that?
Customary international law is international law that has evolved by practice and has evolved in such a way as to be accepted international law, even in the absence of treaty law. And so that's customary international law, as opposed to general treaty law, which is the most accepted and the most common because the sovereign states actually ink and sign a particular treaty.
So may I get your view on this one? Is there any customary international law saying that a foundling is considered a national or citizen of the country where he or she is found?
Since the international law abhors stateless individuals, it has evolved over more than centuries that the foundling is accepted as a citizen and ward of the state.
So there is a customary international law on that. So the last question, Ambassador. So you've been mentioning earlier about global competitiveness and the rule of law. We all know that in order for us to be globally competitive, we have to increase our rule of law index, the performance. No? So, and one of the barometer or one of the key to increase or elevate our standing in this rule of law index is the adherence to good governance. So what would be your concrete plans if ever appointed to become an Associate Justice of the Supreme Court, particularly tackling the principle of accountability? No? Your plans in order to attain this good governance, thereby making us increasing or putting us higher in our ranking insofar as the rule of law index is concerned.
Thank you for this question. Since being in Geneva, we are lovers of indexes, Human Development Index, Global Competitiveness Index, and bringing the Philippines higher and higher is indeed the goal of us international diplomats representing the Philippines. We have, of course, been put off already the Basel Gray List. And then in terms of competitiveness, we have shown improvements. We are also on the top of the index on women.
What's the latest standing with insofar as rule of law index?
The rule of law index, we are in the, I'm not sure, but it's 30s. I'm not sure of the exact grade, but definitely the goal, if I may answer that in the context of just one member of, potentially just one member of 15, I would definitely be a workhorse on improving our index, which requires, related to my earlier question, justice delayed is justice denied. Of course, the court has already made progress in the delivery output rate. And so I think that is one major factor in the index is the delivery of justice, meaning the speed by which we can resolve cases. The other indexes are government accountability, which is the ability of are showing that there is transparency and availability of information, freedom of information. So there's the beauty of these indexes is it provides us benchmarks and measures by which to attack each one, just like the evidence of the SDG 17.
Ambassador, what will be your concrete plans? Let us focus on the accountability. So how are you going to promote our justice system through accountability so as to increase our standing or to level up our standing in this rule of law?
In terms of accountability, we would have to cooperate with the Office of the Ombudsman and Sandigan Bayan for improvement on those indices that relate to accountability of public officers. At the same time, we would have to contribute greatly to the increased confidence of citizenry in government officials. We would have to also provide for increased responsiveness to government services, whether it's not only judicial, it is infrastructure, red tape. We have the anti-red tape law, which is all this come into the rule of law index because investors are the ones looking at this, and they're looking very much, it has been our advocacy at the WTO to participate in this MISME promotion, which is the promotion of micro and small and medium-sized industries. So ease of doing business is the number one factor for the competitiveness and the rule of law index. So speed of cooperation with local governments as well on speeding up permits as well as with the national government. So it doesn't only affect national, but it has to be down to the level of the provinces and municipalities. But that's a tall order.
You have 4 years, how many years to serve if ever?
3 years, sir.
3 years. You can do that in 3 years. Thank you, Ambassador.
I can only pledge to do my best and more than my best.
That will be my last question. Thank you.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good afternoon, Ambassador. I represent the retired justices of the Supreme Court, and they have coursed through me their questions. Okay, I'll begin with Justice Ascuna. Number one, in what ways have your present position prepared you to be fit for the Supreme Court? I think you covered this earlier, but if you want to add anything, you can do.
Just perhaps on the experience with the WTO panel and dispute settlement system and appellate body, which is their version of the Supreme Court. Those panel decisions and appellate body reports in the WTO are extensive and very detailed and go into specifics of treaty commitments as well as to deliberation on the facts, including the question of precedent and non-precedent. So a lot of these legal issues that impact a collegial body and an appellate body like the High Court provide me with some experience on these the complexities of reviewing past cases vis-a-vis present cases.
Thank you. Second question, what should the Supreme Court be doing differently and why?
On this issue, I have to humbly say that the Supreme Court has been doing quite well in increasing its output and delivery to the people. But given the size of the Philippine population and the number of cases, it seems to be a daunting task on how to continue to increase output of cases. So I guess it's more like doing more of the same, of using digital tools. It is commendable that we are moving to digital filings. And I'm hopeful that AI can be a useful tool. So I believe the use of AI will be the next stage improvement that the Supreme Court can do.
From Justice Abad, what rule governs the interpretation of laws when applied to actual cases?
Is it a rule of statutory construction? So, sorry, Your Honor. What rule?
What rules or what rule governs the interpretation of laws when applied to actual cases?
Well, the court is bound to follow the letter of the law if there is plain meaning in the statute. And if there is some ambiguity, then one would have to go into the intent of the legislature.
Okay, Justice Abad agrees with you. In what area of the law do you feel you can immensely contribute to in its development?
The area of commercial and economic laws and infrastructure. And this goes perhaps to the economic development laws and economic policy planning measures that the legislature passes, all in implementation of the Declaration of State Policy to promote public and private partnerships.
Those were the questions of two Ateneans. The third one is also an Atenean, Justice Brion. Distinguish between strict construction and strict scrutiny. Is there a difference between the two?
Strict construction and strict scrutiny. Strict construction is approaching the law in its strictest interpretation according to its wording. Strict scrutiny, however, involves a detailed and more intensive examination of the facts as they apply, as they will be applied with the law relating to it.
Okay, thank you. Explain fully the concept of protected speech and unprotected speech.
Protected speech is the sacred right of every individual to have free thought and free expression of ideas. And this cannot be curtailed. Unprotected speech is speech that can lead to harm to others, which of course has to have its limits, as one cannot protect speech that can do harm.
Okay, that's correct. What are the essential elements of freedom of expression? What are the essential elements?
The essential elements of freedom of expression involve the protection of an idea.
There are only two. Remember constitutional law.
Free speech.
Yes, freedom of expression, free speech. What are its two elements?
The utterances and words of an individual.
There are only two. One, freedom from previous restraint, and two, freedom from subsequent punishment.
The two elements
Yes.
that
Yeah, you remember
the two
now?
elements that constitute the legal protection, which is there cannot be, of course, a prevention of the speech, and there cannot be a punishment of it's the precursor and the post facto element, which is
Oh.
prior restraint and
We now go to the questions of Justice Tiham. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer.
Procedural due process is an essential element of due process rights. If the procedural due process violations are of a nature as to deprive the accused of substantive due process and an ability to defend himself, it is very difficult to differentiate procedural from substantive due process. In such an instance, the remedies are open to the prosecution to refile the case.
Is your answer? The question is whether you're going to acquit a person accused of such a heinous crime based only on procedural grounds, not substantive grounds.
If the procedure has been violated,
He's just asking your position, if you would consider acquitting.
yes, Your Honor.
Then can you explain your answer?
My explanation would be, I would have to examine, I would consider it, provided the procedural due process violations are of such that would impact on the substantive rights of the accused. In such a case, consideration will be given to the acquittal without prejudice to refiling.
Unless there is double jeopardy.
But if it's procedural due process, sir,
Yes.
there will be a defect. That is the question on double jeopardy
Yes.
will arise, because if the procedural due process did not attach prejudice, there would be no double jeopardy.
A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation?
I tend to say that I would have to disagree, given the Supreme Court or the judicial branch is often known as the weakest branch of government. Its power lies in the persuasiveness and confidence that the people give to its pronouncements. It can, in some instances, be deemed dangerous if it leads to such a suspicion that the judicial branch has lost its independence, but such danger would relate to its having fused with the other branches of government and not per se the judicial branch itself.
What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution?
Birthright citizenship, from my understanding, is the automatic and constitutional grant of citizenships to those of Philippine parentage.
You may not answer this. Only if you know, in the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice?
I'm not aware of a 10th justice.
It's okay. This is a related case. What is the doctrine of Rule of 4 adopted in the U.S. Supreme Court?
Rule of 4. The 4 justices.
Only if you know, if you have come
No,
across
I'm not
it.
familiar with the Rule of 4.
Thank you. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decision of recent time do you disagree with vehemently?
As a member of the bar, I agree with the decisions of the Supreme Court. As to vehemently disagreeing with any of recent age, I have not had the experience of this emotion.
Anyway,
I have been told that the quality of a judge is to remain to have less and less emotion in order to be able to listen to all sides.
Ambassador, what is emotional intelligence?
Emotional intelligence, as contrasted with studious intelligence or brain intelligence, is the ability to correlate with other persons in an empathic and human way. Intelligence often in the general, as a general trait, involves study, competence, intense work, and review with diligence of materials or homework. However, emotional intelligence is innate. It is often a result of your upbringing, interactions, and ability to connect with fellow workers, colleagues, friends, and relations. It's an ability to understand without the need of speaking and knowing your boundaries as well.
Is it part of judicial temperament?
I believe so. Because judicial temperament involves a state of mind by which one is able to act with independence and impartiality, since a judge is called to listen to many sides of an issue. The judge is called to arbitrate and decide conflicting issues between two sides. So judicial temperament requires as well as a plus the ability to read others and be sensitive to their own inclinations, attitudes, perspectives, and views. Thank you, Your Honor.
You have, according to you, you have been reading Supreme Court decisions earlier. Are you aware of the Valenzuela case? A mala prohibita case. Are you aware of that? Yes?
Yes, the Valenzuela case.
Meron siya. Meron din ako, sasabihin niya.
Yes, I believe the Valenzuela case is about...
You may recall it. It was stated there that
Valenzuela versus people.
yes.
Intent to commit a crime is different from intent to perpetrate the act.
Yes. What is your understanding of that?
Well, in Valenzuela, it was more to clarify the distinction between what is required or elements of mala in se and mala prohibitum. Or mala prohibita, as some, malum prohibitum or mala prohibita. It basically goes to the concept of mens rea. In traditional criminal law, mala in se or traditional crimes, there is mens rea or almost intent to do wrong. It is almost...
Mens rea, it's different from actus rea.
Yes. So, mens rea involves an element of moral turpitude or mala fides, while mens actus is just that you're doing an act. For example, you intentionally wish to cross the street. So that's, you are doing it as an act. And intentionally, there is intention. But there can also be no mens rea in that action. So in malum prohibitum, as long as the element of the action being done is completed, it can be penalized because the law does not require mens rea or, while in mala in se, often there is a requirement of mens rea in mala in se. However, modern discussions, as pointed out in International Rice Research Institute versus NLRC, there is very little, in each case, whether there is moral turpitude or not, has to be a determination by the judges or the courts by looking at all the facts. If you have an intentional jaywalker who does it like 10 times, he is already, there is already some action of repetitiveness wherein he's violating the ordinance again and again. And so, while it's malum prohibitum, his actions of malum prohibitum can reach a level of intentional violation.
In Valenzuela, which you read, the act there was mala prohibita or malum prohibitum. In mala prohibita, intent is immaterial.
Yes, as long as the act is committed.
If intent is immaterial, why do you have to prove intent to commit the act or perpetuate the act as the Supreme Court use it? Gusto kong itong kaso.
The element is voluntariness. So it's not necessarily the element of mala prohibita requires that you voluntarily did it. If you were drugged and someone is leading you to cross and jaywalk, there's no voluntariness there. So the element required in Valenzuela is proof of the voluntariness of the act. But I don't know, Your Honor, if perhaps you disagree with Valenzuela, and I point more to international rights research as the more modern approach, where it says that many mala inse or acts in the criminal code can be innocent or without mens rea, and many can also be malum prohibitum. And many malum prohibitum can also have mens rea. So it depends. The facts
Depends on what?
The facts have to educate. As they say, this is where intense scrutiny requires judges to examine the full circumstances and facts. The law cannot just be read in isolation from the actor. Because the law is merely a tool of order. And once it is applied, it has to apply to someone and particular circumstances.
It is your understanding then that intent is immaterial. But why do you have to prove intent to perpetrate the act? Hindi naman siya mag-explain, si Ben dapat mag-explain. Mahirap talaga.
Well, you're speaking of Valenzuela, no?
Yes.
The court merely explained
Ah,
that voluntariness was what it was looking for, not necessarily the intent to act. It was just looking for the volition
Volition.
of the person in performing the act, because the moment the act is performed volitionally, voluntarily, the person should and can be penalized.
that is not required in every case of mala prohibita.
Often, yes, often, no, in most mala prohibita should be semi-automatic.
Yes.
Just like nowadays when the radar catches you over speeding or passing a toll, you usually get your fine automatically. But then the computer, because it's evolved that the voluntariness is presumed and de facto evidence. So in a way, it reconciles with Valenzuela by modern technology, because how can you move?
About marital violence due to about psychological violence due to marital infidelity. Is it mala prohibita or mala inse? It is a special law, a violation of BAUSI.
That is why in the international rights research issue, where we use constructs of mala inse and mala prohibita, they are tools for understanding the structure or purpose of the law. Yes. However, in an infidelity case, it is the legislatures recognize that there is a natural negative reaction to the infidelity. However, the legislature also recognizes that you must be able to control your anger and your disappointment. And the policy direction is towards the best practices we have in the world, towards higher levels of understanding, is that we must appeal to the higher self. So that is the legislative guidance that
So what is it? Mala prohibita o mala inse?
it's mala prohibita. It's mala prohibita because he may have lost control of his action, of his rage, but it's still punishable.
Actually, the court was divided. But had you been with the court, you would have been in the minority.
Minority.
Yes. It's all right. The court is divided. Yes. How about psychological violence for failure to provide financial support? Mala prohibita, mala inse. I will guide you. It's the Acharon case.
So that would be mala inse unless it is used for annulment and lack of capacity to marry.
Again, you're consistent. It's mala prohibita. But it's all right, Ambassador. Thank
Yeah,
you
because-
very much. That
yeah.
will be all. Your excuse.
Thank you, Your Honors.
Thank you, Justice Mendoza, and thank you, Honorable Ambassador Manuel Antonio J. TEEHANKEE. Your Honors, the last candidate, but certainly not the least, to be interviewed for the position of Associate Justice of the Supreme Court is the Honorable Court Administrator, Raul Bautista Villanueva. Good afternoon, Court Ad. The first to interview Court Administrator Villanueva is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, Court Ad Villanueva. How are you feeling?
My cup is still here, so hopefully I can last to continue answering Your Honor. That's the only thing I want, actually.
All right. You were a former Deputy Court Administrator and now Court Administrator. Can you name your significant accomplishments which you think has an impact in your application for Associate Justice of the Supreme Court?
Well, insofar as my position right now is concerned, Your Honor, I've been placed in a position which enables me to do a lot of things that it's connected with both adjudicative and administrative work. I'm able to, of course, provide policies, of course, with the permission and approval of the court to judges and court personnel nationwide. But at the same time, not only so far as administrative matters are concerned, but also in the discharge of their judicial duties, especially our judges, first and second level court judges, Your Honor.
What is your policy, if any, in addressing persistent issues of delay, especially in the remote areas and under-resourced trial courts?
Well, what we did, Your Honor, is, of course, we focus on cases that are aging, for one. So with, of course, the permission of the Chief, I discussed that with him, Chief Justice Alexander Gasmundo, and asked permission that we require our judges to give priority to aging cases, those that are aging for 5 years and for more than 5 years and up to 10 years, and then 10 years and above, Your Honor. And actually, I think based on reports that we have received, much many aging cases have actually been disposed of, and much has been accomplished insofar as addressing these matters about delay. Likewise, Your Honor, insofar as reminding our judges about the need to always comply with our rules, especially those that will help expedite the disposition of cases.
Have you encountered a situation wherein you reminded a specific judge about the delay and yet no action was taken? What was your next move, if any?
Well, Your Honor, the work of a court administrator involves a lot of communication being done with particular judges, especially if there is a need to call their attention on matters that they need to attend to. More often than not, they respond positively. But if they don't, of course, the Office of the Court Administrator has this authority to, of course, determine whether or not there's a need for them to be at least investigated, especially if there are many reports being received regarding their work, Your Honor.
What qualities do you believe are essential for a Supreme Court justice, and how do you embody these qualities?
Well, for one, an Associate Justice of the Supreme Court should be learned. He or she should know what he's getting himself or herself into. Likewise, I think he should really want it, Your Honor, meaning that he should have prepared. He should have placed himself in a position where he or she can get that opportunity to become an Associate Justice of the Supreme Court. Likewise, Your Honor, I think hard work comes into play insofar as the work of a justice is concerned. It covers both adjudicative and administrative matters that need to be dealt with. And I think, you have to continue learning, Your Honor. And then you have to adapt to the environment, especially in dealing with members of the court. It's no easy to deal with very prestigious members of the Supreme Court, especially if you're coming in as the youngest, Your Honor. But I think that is something that you have to be prepared for as well.
How young are you? 62.
Yes, I just
So
turned
if-
62, Your Honor.
If appointed, you will have 80 years.
Yes, Your Honor.
You mentioned about continuous learning. How have you kept yourself abreast with the recent Supreme Court decisions?
Well, for one, Your Honor, I teach in a law school. Although
What subject?
my subjects are insurance and legal and judicial ethics, as I was about to say, Your Honor, although it's limited, but this enables me to, of course, look into cases that are related to the subjects, but also with respect to other cases that I need to look into as well. And my office, I receive copies of decisions. Of course, I do have a lot of work, but nonetheless, I still find time to do so, to read these cases when I'm able to do so, Your Honor. And of course, exchanges, insofar as my staff is concerned. I especially when I get to, I'm interested in something that I would like to check on. So all of these things, Your Honor, it's an everyday thing for me, to be honest about it, Your Honor. The learning is an everyday thing to me.
What is your opinion on Supreme Court decisions which overturn judicial precedents? And if appointed to the Supreme Court and this ruling is not something you agree with, how will you handle a situation like that?
Well, for one, I don't think it's not an unusual thing that decisions are being reversed, especially when it depends as well on the composition of the court. So to me, it is something that I will, of course, I welcome in a sense, because it gives him the opportunity to find out why there was a need to do that in the first place. And then second, Your Honor, of course, if I think I should insist on a particular doctrine that should not be reversed, then of course, this is a collegial body, Your Honor. I will have to do a lot of convincing just to have my position, no? Obtain the majority. But if not, Your Honor, then I will put on record, no, what I feel should be the doctrine regarding a particular matter.
What are the essential requisites in the exercise of the court's power of judicial review?
Well, the basic things, Your Honor, is that there should be, of course, an actual controversy. There is a case, of course, that should be brought before the court. Likewise, if it's brought before the court, then the party bringing that to court should have the standing, no, insofar as that a particular matter is concerned. Likewise, Your Honor, of course, the matter, no, the subject matter that needs to be dealt with, if there is the subject matter is subject to review or ripe for the judicial review, should also be taken into account, Your Honor. And of course, what is brought before the court is something that requires it to be decided upon, Your Honor.
You did mention that one of the requisites is that the person challenging the act must have locus standi
Yes, Your
to
Honor.
question the validity of the subject act or issuance. How may the court relax actions filed by non-traditional plaintiffs like ordinary citizens, taxpayers, and legislators?
I think, Your Honor, the Supreme Court has come up with a lot of rulings on locus standi, Your Honor. At times they are lenient, at times they are not. I think one of if I remember correctly, one of the cases that I read with respect to locus standi is the case of Gio Samar, Your Honor, that was actually penned by Justice Ardilesa. Actually, the reason why I remember that is because I just wanted to find out why he was actually espousing to do away with transcendental importance, because that is part of the rules of the court, actually, if there is transcendental importance, that immediately you should allow it. But I agree with his position that when there are facts that need to be received, then another court should do that instead of going directly to the Supreme Court. So basically, Your Honor, my answer to your question is, like I said, it may, of course, the transcendental importance is still there. Of course, if there is an actual injury on the part of any party, then that is also needed, because otherwise there would be no reason for that case to be brought before the Supreme Court.
What are the two tests for a valid delegation of legislative power?
Well, it should be clear and it should be complete, Your Honor, insofar as the delegation is concerned. So to my mind, those are the basic requirements, no, insofar as the delegation of power is concerned.
Let me ask you about executive privilege. The House Committee on Peace and Order conducts an inquiry in aid of legislation into alleged death squads and vigilante groups of the Philippine National Police in alleged informal alliance with the CPP and PA. Implicated are high officials of the palace. The House Committee summons the DILG Secretary to appear and testify. However, the Secretary refused to appear and testify, invoking executive privilege. May the Secretary be compelled to appear and testify?
Well, for
And
one,
please explain.
yes, sorry. Well, for one, Your Honor, what is provided for in the Constitution is that, of course, heads of government, heads of agencies can appear, of course, with of course, clearance, no, so to speak, of the President. I think, to my mind, if that's in aid of legislation, so long as the rights of the Secretary, no, of the DILG is respected, and of course the aid of the inquiry, no, is based on the rules, no, promulgated by Congress or by Senate in this particular case, Your Honor, then the President, no, can allow that to happen, Your Honor, to my mind.
So the answer is yes or no?
Yes, Your Honor.
Yes.
Yes.
Who can invoke executive privilege?
Well,
Can the DILG Secretary
yes,
refuse?
Your Honor.
He can refuse?
to my mind, Your Honor, if the President says that he should attend, then he should, Your Honor, because he represents the President. He's the alter ego of the President, Your Honor.
But would you know who can refuse?
Well, I think because once he is allowed to go and then he decides not to, then that is his prerogative already, Your Honor, because he's been given already that authority to do so.
Senate versus Ermita says it's only the President or the Executive Secretary by authority of the President in writing who can invoke executive privilege. What are the twofold aspects of the right to religious profession and worship?
Pardon, Your Honor?
Twofold aspects of the right to religious profession, right to exercise one's religion. What kind of freedom do they enjoy under this right?
If I remember correctly, Your Honor, insofar as religious worship and freedom is concerned, that's forever allowed, Your Honor, insofar as what is provided in the Constitution is concerned. But insofar as the twofold aspects is concerned, to my mind, of course, so long as the separation of church and state is, of course, always upheld. And second, Your Honor, insofar as, of course, so long as there will be no entanglement insofar as government policies are concerned, Your Honor, then that is something that they can expect to enjoy.
So this is the freedom to believe and the freedom to act on one's belief.
Yes.
Yes. In a decision penned by my colleague, the Honorable Justice Mendoza, this is a case about the holding of mass in the Quezon City.
I remember that, Your
All
Honor.
right.
That's with respect to the
Yes.
Valenciano case.
What doctrine was applied?
Well, in that particular case, Your Honor, of course, there's supposed to be no preference insofar as the exercise of religion is concerned. That's why what happened there is that while others are allowed to express their belief or to enjoy their religious freedom, it should not in any way affect the others. That's why in Quezon City, if I remember correctly, in that particular case, masses before, and in fact, there are some religious items that are being displayed are no longer allowed to be displayed simply because it should respect the religious freedoms of others, Your Honor. So it should not be limited to one, Your Honor.
Were you already the court administrator then?
No, I was
Not
still
yet.
deputy court administrator at that
deputy.
time, yes. I
Oh,
remember
so you
that
heard
particular
about
case.
it?
Yes, Your Honor. I remember that case.
There was a doctrine applied in the case. Would you know?
Must be benevolent neutrality, Your Honor.
Right. And what does this say?
Uh,
What is the doctrine about?
Well, it allows religious separate religious forms of worship is allowed, so long as, of course, it will not in any way be something that will be imposed on others, for one. And second, like I said, Your Honor, it should not be something that will affect also the exercise of freedom of religion of others, Your Honor.
My last question. What are the instances when the court may still pass upon a main issue although the case are already moot and academic?
Well, one, Your Honor, is that when the case is something that can continue to be evading review, but can be repeated, So, to my mind, Your Honor, that is something that can still allow the court to make a decision even if the case is moot. And likewise, if it's intended to provide some guidance for the bench and the bar, Your Honor.
Any more?
Well, I guess for now, that's what I would like to say, Your Honor.
When there's grave violation of the Constitution.
Usually, Your Honor, yes.
Okay, that's my last question. Good luck to you, Cordat.
Thank you, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Marife. Good afternoon, Court Ad.
Good afternoon, Your Honor.
So you have a cough.
Yes, Your Honor. Unfortunately.
You have to drink a cup of lagundi
Yes, Your Honor.
to expel the cough. I have two sets of questions here. Court Ad, one comes from the Secretary of Justice. I'll read it first. Then I'll follow it with my own set of questions. So number one, as court administrator, what reforms have you spearheaded to enhance transparency and reduce judicial misconduct? How would you continue these efforts if ever appointed to the High Tribunal?
Well, through circulars that we're issuing, Your Honor, we're able to provide guidance and direction insofar as how our judges should be conducting themselves, and even our court personnel. On the admin side, Your Honor, for example, if, insofar as addressing situations that affect them personally, Your Honor, like for example, decisions that are being faked, some people that are pretending to be them, Your Honor, or even some or to be personnel, no court personnel. We've come up with issuances regarding these matters. Likewise, Your Honor, I think we have provided guidance to make sure that everyone is on the same page. Like for example, insofar as there's no need anymore insofar as release orders are concerned for those convicted felons who have already served their sentence. That is something that has caused a lot of confusion because some detention facilities, especially the national detention facilities, would not want to release convicted felons even if they have served sentence because they want a release order coming from the court. So we made it very clear that these are the things that we don't need to do, and it's something that the DOJ actually, through the national penitentiaries who should be acting on it already. Likewise, Your Honor, I hope you don't mind, one more thing, insofar as, because of what we're doing right now, insofar as the SPJI is concerned, there's so many things that require our courts to follow. Especially there are other things that are being developed for them to likewise comply with. And one of these is, of course, the Code of Judicial Conduct that is being enhanced for purposes of ensuring that everyone is on the same page insofar as how to efficiently carry out and discharge their duties.
So the second question, you have taught legal and judicial ethics. Well, probably you're still teaching legal and judicial ethics. What do you believe is the most persistent ethical challenge facing our judges today? And how can the Supreme Court address it institutionally and doctrinally?
Your Honor, I'm not teaching right now at the New Era University. I took a leave only for one sem. But I guess insofar as that question is concerned, the one thing really that I think should be given focus is issues on corruption, Your Honor, because that is the thing that is usually being pinpointed to as perhaps the reason why some parties may have lost in a particular proceeding. And to my mind, it's really unfair because as far as I'm concerned, Your Honor, we are manned right now by very competent, very diligent, and very upright and dedicated judges. And still, that persists, that when there is a losing party who thinks that they should have obtained some legal victory, so to speak, and yet they did not, they usually say that there must have been some form of corruption that has taken place.
You led the judiciary's budget defense from 2015 to 2024. What lessons did you learn about the judiciary's fiscal vulnerabilities, and what fiscal policies should the Supreme Court assert more strongly?
I think what we are pushing for right now, the fiscal autonomy bill, will tell a lot insofar as what we would want, insofar as the way the budget of the judiciary is being handled, being deliberated before Congress. What we have experienced during all these years is that every time we go to Congress, or before we go to Congress to defend the budget, the DBM already has cut the proposed budget of the entire judiciary. And what we are defending is the cut version already. So the fiscal autonomy bill, based on that experience, among others, Your Honor, enables us to, of course, still go through the process, the budget process, but instead of the DBM doing the cut, it will be before Congress. That is one of the things that we have determined that needs to really be addressed right now insofar as our budget is concerned.
So the fourth question, what unique perspective do you believe that you can offer that our current members of the Supreme Court may not possess?
Perhaps it's not that they do not possess it, Your Honor, but perhaps something that I can bring to the table, so to speak, the idea of because in the Constitution, the Supreme Court can work in divisions of 3, 5, and 7, Your Honor. I believe we should try working in divisions of 3 to address matters that can readily be disposed of, perhaps. And then likewise, Your Honor, the Constitution likewise provides that the period in deciding can actually be adjusted, or at least the Supreme Court can come up with a policy to try not to maximize the periods as provided in the Constitution, Your Honor. But of course, only with respect to some cases wherein a shorter period is possible.
Fifth, it can be said that our Constitution share some similarities with the U.S. Constitution. As hopeful to become a final arbiter of constitutional issues, can you pinpoint to us one particular constitutional principle that you will strictly guard against being influenced by U.S. jurisprudence, albeit similarities in our Constitution?
If everything is similar, Your Honor, then I will push for one, and that is Section 16 of Article 3, wherein it is stated that all persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, and quasi-judicial bodies. Because at the end of the day, Your Honor, we're measured by the cases that we are able to dispose. In fact, every time we go to Congress, our major final output is usually how many cases we have disposed. Nothing more, nothing less. While we are more than that, Your Honor, we are very much more than that. The judiciary has more to offer than just deciding cases, Your Honor. But I think this is something that we should really see as being properly observed, Your Honor.
With your long years of practice of law and now as an applicant for a Supreme Court justice position, can you share to us your judicial philosophy?
It's not far from what I just mentioned, Your Honor. Actually, it's inspired by the old provision of the Code of Professional Responsibility, not to delay any man for money or malice, Your Honor. We always believe that our work, despite whatever it is that we're doing, if we're not able to decide cases in the most expeditious manner, it will speak volumes about us. To me, all the hard work will not bear any positive outcome if we're not able to do that, Your Honor.
So the next, do you have a particular justice here or elsewhere whom you consider an idol and why?
I will say this with all sincerity. It's Chief Justice Alexander Gesmundo. I've had the opportunity to work with him even before he became an Associate Justice of the Supreme Court. I've seen him work, and I've seen how he makes sure that the job gets done. He has a great mind. and of course, but a greater heart, especially when he was already given this position that he has right now. So to my mind, sometimes I would, although I mean no offense insofar as when I say that I find a little of me in him. Only a little, not much.
Which part daw? Justice. Okay. Assuming you were appointed to the Supreme Court and given the long number of years that you will be there, what do you wish to contribute thereto and to the whole judiciary aside from decision making?
Well, I would want to contribute being able to provide the proper guidance for not only the judges and court personnel, but even here in the Supreme Court proper itself. I would want to contribute to the reforms, not only what is provided in the SPJI right now, because I'm sure after the SPJI, there will be a little or a lot more, doesn't matter, so long as we continue moving forward. And I would want to be in step in everything that is being done in order to come up with the best administration of justice that we can ever offer.
Yeah. The ninth question. In the context of criminal law, how do you reconcile the principle of nullum crimen sine lege, or no crime without law, with the evolving nature of crimes in digital age, such as cybercrimes and artificial intelligence-assisted offenses? Should the judiciary have the power to recognize new crimes even without any legislative provision?
I don't think that is possible. That would be unconstitutional to my mind. For one, you cannot punish anyone without a law. That's very clear. And as the judicial branch, we should be the first, not the last, to violate that particular principle, Your Honor. We cannot render opinions, unfortunately. We cannot, of course, come up with judicial legislation. But perhaps the judiciary can actively participate in discussions regarding, of course, the need to come up with legislation insofar as crimes that are not covered right now, specifically, because of the advent of technology, especially regarding social media, Your Honor. So, but to my mind, we'll have to stick with that particular principle, Your Honor, at this time.
The principle of proportionality requires that the punishment must fit the crime. How do you view the constitutionality of mandatory minimum sentences which limit judicial discretion? Should the judiciary have the authority to invalidate such laws if they lead to unjust results?
To me, I will have to maintain the position, Your Honor, that if it is provided for by law, then we have to follow it to the letter. There's no, it may not be proportional to the kind of crime that is being punished, Your Honor, but it is not for us to decide to change the punishment, the penalty that should be imposed until legislation says otherwise, Your Honor.
So last question from the DOJ. In your view, does the doctrine of presumption of innocence extend beyond the trial stage to public perception and media coverage? How should the judiciary protect the presumption of innocence in an era of widespread media sensationalism?
I wish we could do something as an institution, Your Honor, but apparently we cannot. But to my mind, of course, the presumption of innocence is basically, insofar as criminal prosecution is concerned. And of course, it ends there when there is, of course, a verdict already, Your Honor. Unfortunately, when the person comes out, even if he has been declared or judged as not guilty, media might come up with their own position and say that that person is still guilty nonetheless. But to me, that is not for us to try to defend, because the decision speaks for itself. As far as we're concerned, if there is a judgment of acquittal, then that is it, Your Honor.
So these are my own set of questions. If appointed court ad, what can the stakeholders expect from you?
Well, they can expect somebody who's ready, Your Honor, to become a member of the court. I've been in the judiciary for the past 22 years. I think perhaps without wanting to, but now placed in this position, I can, no? I can deliver what is needed insofar as the work of an Associate Justice of the Supreme Court is concerned.
So far, Court Ad, what is your biggest contribution to the judiciary?
I'm taking a while because I don't know if it's many or too little. But I think perhaps leadership is something that I can say that I have provided in one way or the other. When I was a judge, I was not just an ordinary judge, if I may say so, because I have served also as an executive judge, and likewise, I was involved in the Philippine Philippine Judges Association insofar as helping, no, not only improve our situation, especially in areas that requires us to lobby for something. Like during that time, we had to lobby for a higher pay, Your Honor. Because when I joined the judiciary, I was only receiving about 20,000 a month. And actually, I took a loss, no, so to speak, insofar as compensation is concerned when I joined. But it was something that to me was the right decision as it turned out, Your Honor. Anyway, and then when I transferred to the Office of the Court Administrator, this further, no, provided me the opportunity to provide the kind of leadership that was able to, if I may say so, Your Honor, because I was already in the court during the time of Chief Justice Corona, all the way up to now, Your Honor. And in between those years, there were so many things that have happened, Your Honor. I would want to say that that was something that I was able, no, to provide as well, in the sense that leadership and stability, Your Honor. And basically, that's it, Your Honor.
So you were a legislative staff consultant for 4 years, Quartat, no?
Yes, Your
So
Honor.
under whose office?
That's the office of Dante Liban.
Dante Lipan. So what were your duties and responsibilities then?
Principally, I was doing legislative work. I was drafting proposed bills, Your Honor. And of course, doing the rounds, trying to determine, doing some research, trying to determine what else, no? What proposed legislation can still be done in order to provide the needed assistance, no, for the congressman I was working for at the time.
You stayed there for about 4.5 years. So why did you leave the office of Congressman Liban?
Actually, during those years, I was also engaged in the private practice of law, Your Honor. So I was given the authority. I asked the authority from the Speaker of the House at the time, because that was the requirement. So that's a reason why, Your Honor, that from there, I went to private practice. And actually, I was doing a lot of things. I was multitasking every time. Every time I was in one office to another, Your Honor.
So that's when you joined Magtanong, Acosta, and Villanueva.
Yes, Your Honor.
So you asked questions during that time.
Actually,
Magtanong
before Acosta, Your Honor, was we have a lawyer named I forgot the first name, but Attorney Ke. And so we placed his name in the middle, and then it was Magtanong Ke Villanueva Law Office.
So you answered all the questions then?
Yes, that's what I was about to say, Your Honor.
You should have
It
put
became-
up a call center. Yeah. Okay. And then, why did you leave magtanong kay Villanueva? Probably you get pounded with questions. Aside from that,
Well, perhaps...
you stayed there for 2 years, from
Yeah.
1997 to 1999.
Yes, Your Honor. Actually, perhaps being young, not knowing what to do insofar as your career is concerned, I was trying to find my niche, Your Honor. And then I was asked to work in a government office. So actually even before that I joined the law office, and then I came up with my own law office, Your Honor. And then I was invited to join a government office already.
So you had a brief stint with APT,
Yes, Your Honor.
which is now PMO.
Yes,
So,
Your Honor.
why only stay there for about how many? Almost 4 years.
Yes. Like I said, I enjoy multitasking, Your Honor. I really like doing a lot of things all at the same time. And it was then that actually I became a deputy privatization officer. And as a deputy privatization officer, I was next in line to the
So
chief.
why did you leave? You're about, if something happens to you will be the one promoted.
Yes, but apparently there is a need for you to be known to the president, no, at the time. But at any rate, then the opportunity to join the judiciary came, and that's why I left, Your Honor.
So since you are from the PMO, I'll ask a question about the PMO. So this is the question. So we all know that PMO is in charge of administering properties.
Yes, Your Honor.
So a property has been placed under the administration of PMO. So PMO now list this property, let's say to Raul Corporation. Okay. Now, the term of this lease expired, and there is now a need to negotiate the terms and conditions, no, for the renewal of the lease. Of course, the PMO, as you know that, no, you've been there, you would offer a lease which is prevailing, no, within the vicinity at the time, so that the government will not be prejudiced by the rentals. So there was an offer. The Raul Corporation says, well, it's too high. We cannot pay that amount. So there was a deadlock. What Raul Corporation did is to file a petition for consignation for the rentals, specific performance to renew the contract, and TRO. So during the pendency of this case, the PMO filed an ejectment suit. This is actually a real case, no? Now, the question here is, should the consignation, the specific performance, and the TRO case be held in abeyance, or should it be dismissed because or by reason of the ejectment suit filed by the PMO?
Well, Your Honor, because if the situation is that the lease has expired already, but there is a negotiation ongoing insofar as that is concerned, and it involves the same parties, not to the lease, then to my mind, Your Honor, that ejectment suit, a defense, no, can be raised insofar as that ejectment suit is concerned, because the right to possess still is not yet been terminated, no, so to speak.
The question is, in that ejectment suit, Raul Corporation invoked, no, the matter between us, the PMO, and my corporation is about the interpretation of contract. There is a deadlock on how the renewal clause be interpreted.
Yes.
So that was the defense hoisted or raised by the Raul Corporation. So the question before the Supreme Court in that case is, can the MTC, no, or does the MTC have the authority to rule, no, provisionally rule on the interpretation of that
The-
contract?
The contract, which is subject to renewal, Your Honor. Well, like I said, Your Honor, to my mind, if that is the situation, Your Honor, it is being invoked right now by Raul Corporation because they consigned already, then to my mind, that can be a valid defense, Your Honor.
Your brother-in-law is a barangay XO.
Yes, Your Honor.
I'll
Yes.
ask you about election law. I only ask questions related to your personal lives.
He is my only brother-in-law, Your Honor.
The most handsome brother-in-law
Yes, Your
because
Honor.
he's the only one.
Yes, because there are only two, Your Honor.
Okay. This is the question. No? During election period, barangay election period for that matter. So, what's the name of your
Gerard.
Jared?
Gerard.
Gerard. Okay, Gerard. But this is the same, different Gerard I'm referring to. It's just a namesake. No? Gerard was caught during the barangay election period. Gerard was caught possessing a firearm. No? Of course, the police filed a case against him for the violation of the Comelec gun ban. The following day, that I was arrested, there was a law which postpones the barangay election. Now, he filed a motion to quash, saying that there is no election law, and how can I be convicted and even prosecuted for violation of election law when there is no election to speak of? So, what do you think? That's a Supreme Court decision also.
To my mind, the crime has been committed already, Your Honor. Even if the election was postponed, then you can still be charged.
The issue there is, should this law postponing the barangay election be given retroactive effect? Diba? That's the issue in that case.
Well, Your Honor, when you talk about operative fact, sometimes there are some effects of that particular postponement that can benefit him, Your Honor.
Yes. Sabi, diba? We all know that penal laws, if favorable to the accused, can be given retroactive effect. So, would that principle apply to a law postponing barangay election? The Supreme Court says. So, interesting.
But
It can be given retroactive effect. That's a Supreme Court decision. So, you're a graduate of economics in college. Very easy court ad.
I'm sorry, Your Honor. I'm just laughing at myself.
At least it somehow resolved your cough.
So
Because
far, Your Honor.
Because you're now laughing.
So far, Your Honor. Thank you so much.
You are self-medicating right now, court ad. So the question is, there are several economic provisions in our Constitution. So how would you want, or when you become an Associate Justice of the Supreme Court, how would you interpret these economic provisions? We all know that you can be liberal in your interpretation such that you would probably promote economic growth, or you can be restrictive such that giving life to the constitutional provision about the Filipinos should have an effective control over our natural resources. So, given this scenario, how would you interpret our economic provisions?
Well, I guess I will have to take it from there, Your Honor, from your lead. Actually, it will have to be a mix, Your Honor. It will depend on what economic provision will have to be subjected to scrutiny, Your Honor. To my mind, yes, we can be liberal insofar as investments that can come in, but we cannot be too liberal that we will be dominated already by foreign interests rather than our own interests, Your Honor. So to my mind, like I said, I would be stricter insofar as ownership of some of industries are concerned, but insofar as the ability to bring in as many investors as possible, then definitely this is something that I will be liberal on.
Yeah. So, by the way, Courtad, RTC 255 is a family court.
It's a regular court,
Regular
Your
court.
Honor.
267,
267 is a drugs court if you're
Drugs
referring
court.
to the branch in Taguig.
Taguig.
Yes, Your Honor.
How about branch 4 in Manila?
Branch 4 is a family court.
Family court. So I'll ask family court. Finally, I made a right guess. This is actually, there is an absence of law on this, and I want to take advantage of the presence of a judge in a family court. So you're familiar with the declaration of presumptive death, wherein the present spouse can remarry.
Yes.
Okay, let us put this situation. I'm fond of asking questions involving Raul. So Raul is married to Michelle. Okay. So Raul went missing. No? So and Michelle filed a petition to declare him dead so that Michelle can marry your good friend, Oni. Now, under our rules, present family court says, this marriage of Michelle and Oni can only be invalidated by the affidavit of reappearance executed by Raul.
Yes.
But Raul is so wise. He did not execute
Yeah.
any affidavit of reappearance. Instead, marries his childhood sweetheart, Inday. So what is the status of the marriage of Raul and Inday? There is no law actually to cover that one.
But to my mind, well, to me, Your Honor, it would appear that Raul is not that wise. Because,
That could be the same answer from certain Oni. I think I know the reason.
But the reason why I say that is because that will not change the fact that he has reappeared. And of course, that fact of reappearance would require a formality, Your Honor. But nonetheless, the reappearance would, to me, result in the revival of everything about his status and his person, Your Honor. Because the need for an affidavit is a formality, Your Honor. But to me, the reappearance is something that will not in any way result in changing his status.
He is still married
To me, yes.
to Michelle.
Yes, to me, yes.
So Michelle has two spouses right now.
Well, that will be
Only.
considered as that will be considered as invalid, Your Honor. It will be considered as bigamous, Your Honor.
Which one? The marriage of Michelle,
Michelle
and Tony?
and Oni.
But the law says there must be an affidavit of reappearance.
I know, Your Honor, in order to make sure that the effects of him reappearing will happen. But to me, like I said, because there is no law,
Yeah.
then to me, marrying somebody else just because you did not give the affidavit will not be a wise thing to do.
In one Supreme Court decision, court ad, it's very interesting because I don't know if this is the only Supreme Court case with this kind of ruling. The Supreme Court was equally divided, very peculiar, no? Because there are 15 members, but in this case, there is no another member yet. So the case was decided 7-7. So, and it involves the constitutionality of the IPRA law. No? So if you would notice, in that case of Cruz versus Secretary of Environment, the IPRA law was not declared unconstitutional simply because it failed to muster the required number of votes.
Yes.
And you know the issue there, no? The petitioners here, Cruz says, it violates the Regalian Doctrine because you give the our exploitation, development, and utilization within this native land to the IPRA. It's violates Regalian doctrine. On the other hand, the IPs would say this has become privately owned by way of acquisitive prescription, noting that they have acquired it by virtue of native title.
Yes.
You are now, let us say this case is still pending right now, and you are the 15th member who will cast this vote. Which right are you going to sustain? That of the state, Regalian doctrine, or the right of the IPs that would involve their invocation of native title?
I will vote for the state, Your Honor. I think the Regalian doctrine will still have to be recognized insofar as that matter is concerned. I think it's bending too much in providing so much land without, of course, taking into account that there are other citizens of this country who may benefit from distributing this particular kind of property, Your Honor. So, to me, my vote will be to declare it unconstitutional.
So you are the, well, actually, I'll ask question of one member of the academe. So you've been mentioning earlier, and I heard it about your leadership, that you have contributed most to the judiciary. So what is your understanding of transformational leadership?
But I guess readiness to, of course, not only accept change, but also to effect change. We live in a world that is no longer the same like 15 years ago. And developments will be much faster within the next 10 years. So definitely we have to prepare ourselves to be able to not only meet the changes that will come, but to be able to adapt, use all of these changes for our benefit, especially insofar as the work of the judiciary is concerned. And of course, a leader does not leave anyone behind. And that is something that I would want, any leader, for that matter, should always bear in mind that you do not lead by yourself. You have to lead others. So that it's not for you to become better, but hopefully for many to become better.
And that brings me to my next question. Making other persons a better version of themselves. So how are you going to do that, display transformative leadership, given the fact that you are the youngest, or the most junior, the appropriate term, most junior member of the Supreme Court?
I don't think that will be a problem insofar as providing and contributing to the work of the court. For one, there will be cases that I will be handling as ponente. Then definitely, in my own way, that is something that I will work on to show the kind of transformation that I would want. And of course, it's a collegial body. Anything that I come up with will have to be decided as a body. But nonetheless, I will just, whatever be the outcome, it will be fine with me, Your Honor.
Last question, Cortad. So you are the last person to be interviewed for the application, to become an Associate Justice of the Supreme Court. So the question is it fair to ask same set of questions to all applicants in order to determine their competence?
I don't think it's fair.
Why? Let's say, bar examination, di ba? They are the same set of questions to all bar takers. It would quantifiably give us who is better than over the other.
But of course, it depends on the applicant. But to me, it's not fair, in a sense. because I'm sure one way or the other, there's discussion about all these questions even before. But nonetheless, that's what I'm trying to say. No? It depends on the applicant on whether or not it will be accepted by him or her, whatever the information is. I don't know. It may be fair to the JBC, Your Honor, if with all due indulgence, because I know it's difficult to come up with all kinds of questions, and sometimes you might ask questions, easy questions, the first time around, and then the unlucky one, like me, for example, who is the last, might be asked the hardest questions, and so that's going to be unfair, Your Honor. But of course, I accept any, of course, that's part of the process, Your Honor. I am not complaining, actually.
Thank you, Court Ad. And good luck.
Maraming salamat. At may I just greet you at advance happy birthday, Your Honor.
Thank you, Court Ad. Sorry, are you well? You have to play basketball already.
Hopefully, Your Honor.
Thank you, Attorney Firme. Our last interviewers, the Honorable Justice Jose Catral Mendoza.
Thank you, Attorney Marife. Good afternoon, Court Ad.
Good afternoon, malamya po.
I have known you for several years already, so I will have no personal questions to ask. But I represent the retired justices,
Yes.
so I'm going to ask questions propounded by them. Some questions you already covered by your answer, so I will not ask them. From Justice Ascuna, what should the Supreme Court be doing differently and why?
Well, the Supreme Court is doing a lot of good, Your Honor. If there's anything that should be done differently, I think what I mentioned earlier is to try to see how we can make use of what is provided in the Constitution regarding working in different divisions, to try to farm out cases that can be dealt with much faster. Likewise, perhaps, Your Honor, while we're already doing it, insofar as rules are concerned, I guess we have to give emphasis on being able to make sure that cases before all of us are properly accounted for and hopefully duly addressed, Your Honor.
Okay. From Justice Brion, distinguish strict scrutiny from strict construction.
I think when you talk about strict construction, you're talking about interpreting what a particular law may be, Your Honor. When you talk about strict scrutiny, you're talking about whether or not there is compliance, no? If the law that is the subject of a case applies, no, to a particular situation, Your Honor.
What is the concept of protected speech and unprotected speech?
Protected speech pertains to, for example, those pertaining to libel, Your Honor, and hate speeches. I think that is the usual illustration, Your Honor, about protected speech, meaning we have to make sure that demeaning words, demeaning speeches, demeaning statements are not allowed. Otherwise, it might result in, of course, injuries, no, to those who may be affected. So unprotected speech would be the opposite, Your Honor. Those that would not in any way violate freedoms, especially with respect to expression, speech and expression.
Can facial challenge be applied to government laws, rules, and regulations only with regard to protected speech or unprotected speech? Facial challenge.
I think a facial challenge actually applies to a lot of species of insofar as facial challenge is concerned, yes, Your Honor. I think it can be the subject of facial challenge, Your Honor, so far as speech is concerned, because as compared to as applied challenge, usually it's limited, Your Honor.
From Justice Jose Reyes, Joey Reyes, what is slap? Slap.
That's usually a suit that is filed when there is an effort to try to prevent the implementation of environmental laws, Your Honor. Stands for? Actually, I knew it before, Your Honor. But I know the definition. That's a definition, Your Honor, my understanding, that when there is an effort to try to prevent the implementation of an environmental law, Your Honor.
That was the favorite question of Tony Kin, but he did not ask it. So it is a strategic lawsuit against public
participation. Yes, exactly, yes, Your Honor.
We'll go now to Justice TEEHANKEE. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds?
To convict, Your Honor? To acquit? To acquit?
Would you consider acquitting those persons accused
Yes, Your
of
Honor.
heinous crimes?
Well, as a former judge, I would not want, especially when it comes to heinous crimes, Your Honor, that procedural grounds would be used for purposes of acquitting an accused. I would rather that the matter be decided on the merits, Your Honor. Yes, Your Honor.
Justices, sorry. In the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice? You are from the you are with the judiciary. In the Philippines, there are 15 justices. The 16th is Timoy.
16.
So sa US,
Sa US po, I think it's the Solicitor General, Your Honor.
you're correct. Oh. Tinatanong ko lang pag super. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
Not vehemently, Your Honor, but I respect the decisions of the Supreme Court. Every single decision, Your Honor, that I get to read, I get to know about, Your Honor. But there's one case that I would say that should have been decided, perhaps, or should have been ventilated all the more, a little more, is with respect to this case of Falsis III versus Civil Registry General. This is the issue about the definition of marriage between a man and a woman. And the Supreme Court because they considered it still premature, decided to dismiss the petition. To me, that is something that will recur, that issue about allowing same-sex marriages or not, no, legally. And what struck me about that, Your Honor, is because the intention is to try to formalize families, Your Honor. Because in the Constitution, it's stated there that, of course, the family is the foundation of society. And marriage is the foundation of the family. So that issue about not being able to marry, to serve as the foundation of society, no, of the country, to me has repercussions, Your Honor. So that's the reason why. I just remember that, Your Honor.
Any other case?
That I disagree with, Your Honor. I don't want to say the other one, Your Honor.
Okay.
It's a political case, Your Honor.
Yan ang forceful hesitation.
Ayun. That is the last question, Cortato. Thank you very much. I know you're not feeling well. You're excused.
Thank you. Thank you, Your Honor. Maraming salamat po.
Thank you, Justice Mendoza.
Permission to leave, Your Honor.
Thank you, Court Administrator Raul Villanueva. Good luck po. That concludes the public panel interview for the position of Associate Justice of the Supreme Court.